used to happen. See, now days have changed. Multinational companies have come to the field of e-commerce. Thereby, you have been given legal protection, and even the concept of giving compensation to consumer is introduced in this new act. They are the new things they have brought. Further, you may also notice that a new chapter called mediation has been introduced in the 2019 Act. State Consumer Protection Commission can empanel a list of mediation mediators who can mediate things and solve the problems. All these have improved to bring the justice to the doorsteps of the consumers. Further, there were several judgments which also improved the functioning of this act. Now the medical field is also brought under this. If you have undergone medical negligence, it has three folds. One is criminal side, medical negligence, and the other side is the consumer protection field. Here, Supreme Court has also said for the medical negligence, not only doctor will be prosecuted, in addition to that you will be entitled for compensation under Consumer Protection Act. These are the new developments. Unfair trade practice, it is also a big dimension in the new act. Unfair contracts, unfair trade contracts, putting conditions which cannot be fulfilled by a consumer, such contracts will be incorporated. And if such contract is there, you can challenge it. And further, if any product is not up to the mark or the standards, you can complain to the forum or this commission. Even that central authority, what this act has brought central authority, it has power to get it investigated by the Director General, who can go and collect samples, send it to the laboratories regarding the standard of the product. If it is of substandard, he can complain. Then it can, a serious action may be taken to withdraw this product from the market. That kind of provisions have been brought in the 2019 Act. Even unhealthy competition and misleading advertisements is also a big dimension which is incorporated in the new Act. Misleading advertisement can also be challenged, which will derail the customer from your track. It will mislead you and put you into trouble. That can be stopped by challenging those things. So with all these basic hints, I want you to come up with your papers. We are here to listen to your presentation. Thereafter, experts are there to advise you how to improve further your presentation. And one thing I want to say before you make your presentation, don't read bringing all those notes here. That is not permitted. you can bring synopsis or points. Looking into the point, you elaborate it, present the things, then you will be appreciated. With this introduction, I conclude. Thank you. Good morning, everybody.
Good morning, sir.
And today we are here to discuss on Consumer Protection Act 2019. It's a good opportunity from our institute and the Alliance University to have such an occasion. Here on behalf of Alliance School of Law, Madam Kiran Dennis Gardner is here, and B.S. Reddy sir is here. Dr. Ashok Patil, who is a professor in National Law School, is also here with us, and Y.G. Muralidharan is also a great worker in consumer protection field. Today, with all these luminaries, you will be enlightened very much on this subject. Our institute, the Karnataka Institute of Law and Parliamentary Reforms, was established in 2005 by the government of Karnataka, and it is our intention to conduct awareness programs and such seminars would help you students to know about, in your classes, the classes will be conducted and it will be a subject for you for the examination. But when you meet in this seminar, the way in which you learn will be different. It is not a classroom. It will be an interaction session. Here, it is a change. You have to come out with your notes and what all points you have studied over this subject. When you come with the preparedness, you study something and present your paper, you will come across many things. At the same time, you will have opportunity only when you study yourself and come. Otherwise, just like a classroom, if teacher teaches and you will listen and you will go away, that will be a one-way traffic. Here it is two-way traffic. First you must present. Then here are the experts who will say what lacuna is there in your paper, how you should have prepared your paper, how you should present, all these things, along with citations, leading judgments on this. Then you will be more enlightened where you have erred in preparing paper. Even in future, see this type of attempt in making presentation, you will conquer the fearness, stage fearness first. Always see, first year students, it is a better opportunity. For the others, it will be okay. As you go higher and higher studies, it is more frequently required. Paper presentation at different forum is very much required. So from this stage, if you learn, you will first conquer your stage fearness and fluency in talking on the subject. Then first of all these things, you have to put your efforts to search what I should present, what points I must present. The first thing is you will start searching over Google. Right? That will put you into industrious nature. That is very important, and that is the object of this awareness program. It should be both side interaction, not from one way. The other thing is, our institute is conducting this type of awareness programs. We also conduct model assembly sessions, competitions, to know parliamentary procedure among law students. We used to conduct in all the 4 zones of Karnataka, and the winners of 4 zones will be brought to the state level competition, and the state level competition of model assembly will be conducted at Vikas Sauda, next to Vidhan Sauda. And there will be a state level competition, and students will be awarded for best performance. That is also one of the attempts by our institute to bring awareness regarding the parliamentary procedure to the law students. In addition to this, our institute is also publishing research books on law subjects. We have brought about 80 books in English and in Kannada. Especially, we would like to encourage Kannada. It is our official language. And students who are writing exam in Kannada for a state law university, they are facing many shortage of Kannada books. So we encourage research books in Kannada, and that will help them for their studies. Further, as we go into this subject, today's consumer protection, you all know about the law, what was earlier, before 1986 Consumer Protection Act. Before 1986 Consumer Protection Act, do you say there was no law? There was law for consumer protection, but that was not effective, and it was too lengthy procedure. As they say, justice delayed will be justice denied. To overcome such difficulty, Government of India, and based on the UNO conventions and this thing, Parliament felt it necessary to bring a comprehensive legislation on consumer protection, and 1986 Act was brought to force, where procedure was reduced and consumer protection forums were formed in the 1986 Act initially. And another benefit you got in the 1986 Act was there was no necessity of advocates. Even a common man, just on a white piece of paper, if you go before the district forum, that was honored and many problems were solved at district level and state level forums. That was a revolution in bringing justice to the doorsteps of the common man. That was the initial attempt made by the parliament. Thereafter, in 2019, when this act came, several improvements were made after series of studies, and they studied what are the lacunas in 1986 Act, what improvements have to be made. Those shortcomings were addressed, and this 2019 Act came to force, and this is, I call it as a revolution in the field of consumer protection. Consumer rights, there are 6 rights which is already enumerated. You have right to know the contents of what you buy, the fair price of it. Then there will be competitive rates. All these rights have to be protected only through this Protection Act. The only change is in the 2019 Act, they called the forum into a commission. District forum has been called as a district consumer redressal commissions were formed. But the new things they have brought are, they formed commissions, advisory commissions at district level, state level and national level commissions. And they constituted Consumer Protection Authority at the central level also. Further, they addressed what is e-commerce. That is the need of the day. Today, you buy things over Amazon, Flipkart. There, if any product is of below standard, or if you are cheated, then that was not addressed in the 1986 Act. That is the new concept they brought in the 2019 Act. E-commerce, one chapter has been introduced. That is the present day challenge. Day to day, you buy things online. And see, earlier to that, you may not be knowing, in 1970s, 1980s, before these acts came into force, people used to buy online from Delhi, Agra. They used to send one transistor for 100 rupees. If you open that, it will not work. If you go to court, you can't reach the person, he will be absconding. See, such things were
Thank you, ma'am. Thank you, guests.
Thank you.
share that the distinguished guest to honor us with his presence today as a chief guest of our event is Shri K. Varaknath Babu, Director, Karnataka Institute for Law and Parliamentary Reform, Bengaluru. Sir had joined the government service in 1983 and served for more than 38 years. Sir served as the Secretary to the Government Department of Parliamentary Affairs and Legislation from 2013. Sir is the member of Academic Council of the Karnataka Law University. Sir had worked more than 10 years as a secretary and also in scrutinizing committee under the chairmanship of Honorable Law Minister and drafted major legislation. Sir had worked as an advisor to the Committee on Subordinate Legislation of State Legislature for more than 10 years. Now, it's my esteemed pleasure to call upon the man of action, Shri K. Varaknath Babu, Director, Karnataka Institute for Law and Parliamentary Reform, to address the gathering. Sir, over to you.
Participants, come here. Come.
Take your mobile phones again. No earphones. In justice, there is a peace. However, justice cannot exist without truth. Always stands up for the truth regardless of who steps on it, and always stands up for what's right regardless of who is committing the wrong. With this note, a very good morning to everyone here today. It's my immense pleasure to welcome you all for the one-day seminar on Consumer Protection Act 2019, organized by Karnataka Institute for Law and Parliamentary Reform, Bengaluru, in collaboration with Alliance School of Law, Alliance University, Bengaluru. I, Bharti, is extremely overwhelmed to get this opportunity to warmly welcome you all on behalf of Alliance School of Law, Alliance University, Bengaluru. First of all, I would like to acknowledge the presence of our esteemed guests. Shri K. Varaknath Babu, Director, Karnataka Institute for Law and Parliamentary Reform, Bengaluru. Professor Dr. Ashok R. Patil, Chair of Consumer Law and Practice, NLSIU, Bengaluru. Shri Y.G. Muralidharan, Founder of the Consumer Rights Education and Awareness Trust, Bengaluru. I thank all the dignitaries for gracing us here today. I would like to warmly welcome the leadership of Alliance School of Law, Dr. Kiran Dennis Gardner, Dean, Alliance School of Law, Bengaluru. Dr. Mukul Saxena, Professor and Director, Center for Postgraduate and Legal Studies, Alliance School of Law, Alliance University, Bengaluru. Dr. Shyam Kishore, Associate Dean, Academics and Research, Alliance School of Law, Alliance University, Bengaluru. Dr. Devya NG, Program Director, BBA and BA LLB, Alliance School of Law, Alliance University, Bengaluru. Dr. B.S. Reddy, Professor, Alliance School of Law, Alliance University, Bengaluru. I should also warmly welcome our respective faculty members, other dignitaries on and off the dais, and the young minds present here today. Before moving ahead, light is a pretty symbol of truth, knowledge, and understanding. It acts as a guide to keep us away from the stumbling dark. Before moving further, I would like to welcome all our dignitaries for the lighting of lamp. Thank you so much, ma'am. Before moving ahead, I will request Dr. Kiran Dennis Gardner to felicitate our venerated guests. The soul should always stand ajar, ready to welcome the ecstatic experience. It's an honor to request our respected Dean Man, Dr. Kiran Dennis Gardner, to deliver the welcome address. Dr. Gardner is a holder of 2 doctorate degrees in law and education. Ma'am's research work is focused mainly on the educational rights of tribals and minorities, which shows her approach towards the importance of education and an educated society. Ma'am, with her busy schedule, stretched her arm towards the welfare of the society by conducting many training sessions for police officials, lawyers, leaders, NGOs, women groups, and students. Ma'am's work in social welfare and legal justice is demonstrated by the fact of her contribution in setting up a legal aid center at the Sabarmati jail. All this social welfare approach that ma'am has done via law as a tool put her in the best position to give the welcome address for the event. Ma'am, over to you.
Thank you, Bharati. Good morning, everybody. Good morning. Good morning. So, you all awake? Yes. Okay, fine, good. With due respect to the dignitaries on the dais, Chief Guest Dwarkanath Babu, Director Kilpad, Professor Ashok Patil, Professor and Chair of Consumer Law and Practice, Ministry of Consumer Affairs, Government of India. Then guest of honor, Shri Y.G. Muralidharan, founder of NGO, Consumer Rights Education and Awareness Trust. My dear colleagues, dignitaries of the dais, and dear students. It's my immense pleasure to welcome all the dignitaries and welcome you all. Most of y'all sitting here are first year students, and it is an experience for you to be exclusive part of this seminar, which has been organized on Consumer Protection Act of 2019. As you study this act, and faculties in the class have dealt with this, given you understanding of this act, and people who have been in this field for a very long time and who have been working for bringing awareness relating to protection, Consumer Protection Act, and who have been working in this field, I think you will get a broader perspective of this act and an understanding of this subject. I would suggest that what you have understood, all of you all have written the papers on this act, and some of these papers have been selected to be presented in this seminar. So I congratulate the ones whose papers are being selected to be presented in the seminar, because in the first year itself, you have made an attempt to write a paper, and you have overcome your fears to come up and stand and discuss what you have understood. And I would also say this is an opportunity for you to not only hear people with vast experience, but as well take this opportunity to clarify your doubts also, because they are in this position as to whatever you ask, they would be able to clarify your doubts. So I would say it would be a great learning experience for you for the whole day, and I hope you enjoy studying, and you enjoy this day. Happy learning. Have a good day. Thank you.
One, sir, for the valuable insight. Thank you is the best prayer that anyone can say. Who else will be the better person than Dr. Devya NG to complete the session with a word of thanks? Now I request Dr. Devya NG, Associate Professor, Alliance School of Law, Alliance University, to deliver the vote of thanks. So over to you. Now it's my time to thank you all. I'll thank the guests. We will be meeting after 10 minutes of a tea break.
I'd like to thank our chief guest, Shri K. Dwarkanath Babu, Director, Kilpar, Bangalore, for delivering the inaugural address. I'd like to thank our guest of honor, Dr. Ashok Patil and Y.G. Muralidharan sir, for gracing the occasion. I'd like to sincerely thank our Dean, ma'am, Dr. Kiran Dennis Gardner, for being a constant source of support and guidance. I would like to place on record our sincere thanks to Justice Kulivadi G. Ramesh, President, Karnataka State Consumer Dispute Redressal Commission in absentia. I'd also like to thank Shri Abhay G. Chabi, Pro-Chancellor, Alliance University in absentia, for his support and guidance. I'd also like to thank my faculty colleagues and staff, and also the student participants who are going to participate in the upcoming session on seminar on Consumer Protection Act. I hope the sessions will be fruitful and you can enjoy the sessions. Thank you.
Has not actually seen or had a lemon will probably think, oh, it tastes really sweet and all that, but when he or she actually consumes a lemon, they will realize that, oh wait, it's pretty sour. That's exactly what the laws are supposed to mean, where the product looks absolutely fine, perfect, amazing on the outside, but when they actually use it or become a consumer of it, they realize that it's pretty defective. So, yeah, and the reason I first discovered this was that you guys know change.org, right? There are like so many petitions there going on and on. So there was this one petition that I saw for introduction of lemon laws in India. Okay, please, let me tell you that it is not in India. So here what I'm trying to say is we need them in India under Consumer Protection Act. So the first time I saw it was under a petition where a person had written his complaint and why he thought that introduction of lemon law was important. And he said that he bought a car, okay? It looked absolutely fine. He was so like happy about it, thinking how he could probably drive with his family and all that. But then it broke down 7 times, and it went to the workshop 75 times, and a total of 2.5 lakhs was covered under warranty. And all this happened under a span of 36 months, and that's when he started to feel like he tried to ask the manufacturer if he can replace it for a new one, but there is absolutely no law which you can do that. So he had to keep going over and over and over to the, like, you know, fixing the car, and that's when he started to feel, okay, maybe we need lemon laws in India, which, let me tell you, is what the basics of the lemon law are. So it is mostly prevalent in countries like USA and Singapore, which has not derived its laws primarily from like the common law, unlike India, which is like in the UK, you know, like the UK law. And the lemon law is different for different states in America, because, you know, in USA, all states have their own, you know, laws. But under the Mason-Moss Act, this lemon law had its basic, you know, like an outlook. And what it says that if you have a warranty for a car, and even after like trying to fix a major defect for like many times, it is not fixed properly, then you can claim for a new car, or you can get like you know, reclaim the money back, and you don't have to do it under a court or anything like that per se, and you can go for arbitration, and under that as well you can choose whether or not you want to keep the judgment that they have given and proceed for the further courts in case you are not satisfied with the judgments. So that being the basic outlook of what a lemon law might be, let me tell you that in India, so the basic is like the Consumer Protection Act, we want to introduce it under that, right? And in Consumer Protection Act, product liability was introduced for the first time in the Consumer Protection Act of 2019. And that's like the only other alternative that we have right now to fix something like a lemon. Lemon basically means like a car that is not functioning properly, okay? So that's like the only alternative we have right now. And you might ask me, okay, if we have the alternative, then why again do we need the lemon law? So let me tell you, in cases where, okay, so let's say, let me take a case for you. Sushila Automobiles versus Dr. Birendra Narayan Prasad. So because of a minor flaw, because of a flaw, he went to the court and they told that no, it cannot be covered and replaced because it's a minor flaw. But then when he appealed for it again, they said, yeah, you can get it replaced because it's a manufacturing flaw. But then again the national committee said that no, it's a minor flaw. So there's like a huge confusion of what can be considered as like a minor flaw, major flaw, and if the warranty can be applied over and over or can be replaced and things like that. And let me tell you, like the major defenses taken by these manufacturers it is that no evidence can be established that there was a manufacturing defect. Basically, they blame everything on the consumer that, yeah, you spoiled the car, so don't come to us blaming it on us that it's a manufacturing defect. And so basically, to conclude it, the lemon laws, like for manufacturers, sellers and distributors, they are obliged to correct defects, and after a reasonable number of trying to correct the defects, if they are not still, if the car is still not, better, then they are obliged to either replace it or refund you back the money. And there are two other laws that you might tell me that you can use, that is the Motor Vehicle Act, but let me tell you, it covers only insurance, which is very different from warranty. And you can also ask me whether the Sales of Goods Act can be implemented, but that's only covers damages, and damages, as you know, usually doesn't come up to how much loss you have lost. It can also, the damages awarded can be lesser than the actual damage, so that is also not really feasible, which is why I think lemon laws in India should be introduced. Thank you.
Dean ma'am, sir, very own faculty and all my peers, it's an honor to be standing here today. I am Ms. Niharika Batra, and I'll be presenting my paper on consumer protection and analysis of the conundrum regarding its applicability in the education sector. Topic is that in a judgment made by the Supreme Court, that is Bhupesh Khurana versus Vishwa Buddha Prasad, it was said that when the institutes are rendering education in exchange of consideration, it is a form of service. Although in another judgment of P.T. Koshe versus LM Charitable Trust, it was said that education is not a commodity and educational institutes are no service providers at all. And there's another pending judgment in front of the Supreme Court right now. So even after almost 4 decades of having a consumer protection provision, we have no clarity if we as students are consumers or not. So it's been really interesting to study this. Although the definition of services under the Act can be, on the basis of the way it's worded, can be divided into 3 parts: the inclusionary, the main part, and the exclusionary. And education has not been expressly mentioned in either of them. Although it is to be seen that there are certain cases like those mentioned in the PPT, where services there's been recognized a deficiency in services in cases of misleading advertisements or a lack in the transparency of procedure. Although it is also to be seen that given that university is included under the definition of state under Article 12, there are certain functions of university which are statutory, and those cannot be recognized under the Act. So in the case mentioned here, it was said that when a board is conducting examinations, it's not a service. So you are basically given a privilege to be attending those examinations. And similarly, in another case, it was said that if a student does not abide with the statutory functions of the university, he'll have to face certain consequences for the same. Although there is a twist here, okay? In the judgment of LDA versus MK Gupta, it was held that that a statutory body's function is not entirely exempted from the provision of the Consumer Protection Act. And in GDA versus Balbir Singh, it was said that the provisions under service and deficiency are not exhaustive, which means that they do have a scope of including the functions of a university in them. These are certain cases where the statutory functions and the deficiency in rendering of those services were recognized by the court of law. Now, as per what has been founded by me, I would, as per the research, what I could find was that the definition of service is not exhaustive. It is open for liberal interpretation, and it is possible to include education as a subset under that. Although, in the light of the aforementioned facts analysis, in the lights of the aforementioned facts, analysis and case laws, I would like to say that we can, to some extent, we can say that services of the educational institutes have been included and we as students have been recognized as consumers. But it is to be noted that there is a perceptible need for the court of law to make a very clear demarcation if between the administrative and statutory functions of the university. And it is also important to note that in cases where there is a deficiency in the statutory function of the university, is it important to prioritize the consumer rights of a student or not? So that's it. I would like to thank everybody for lending an ear to me. Thank you. Have a nice day.
Thank you so much, Niharika. Our next presenter is Sudiksha I.
A very good morning to one and all present here. I'm Lasya and my project title is Comparative Appraisal Functioning of Judicial and Quasi-Judicial Codes in Light of Consumer Laws. So quasi-judicial and judicial codes, these are the two terms we are not yet aware about, much about it. So the reason behind me choosing such a topic, which is more theoretical and mechanical in process than other, I have the other research papers which have tried to find out how can the laws get better, what is lacking in the law. So I have tried to go in much of the theoretical aspect. So in this, for the information, judicial codes here are the civil codes, whereas the quasi-judicial codes in light of consumer laws is the consumer commission. So what I want to say here is the civil codes and consumer councils are completely different. They are different because of many aspects which makes it unique. So why is it, why there was a need of putting consumer council into quasi-judicial than a judicial is something I have worked upon. So firstly, I would like to Firstly, I would like to differentiate how civil codes are different from consumer councils. Consumer councils, as I said, are quasi-judicial codes and the proceedings are very much shortened as comparatively to the civil codes. So first we'll speak about the monetary elements of the code and its proceedings. So civil codes are very much expensive in comparison to the consumer codes. This provision allows the consumer to sue the wealthy companies and firms. Only because of this, even though if we are facing any losses such as suing a company which is a manufacturing of car, or suing a company or a MNC which has caused some kind of loss to the other company, it is only because the allowances and the fee which is charged under this act is very much reasonable or it is nothing at times. The next is the three-tier hierarchy structure. As we all know, just as a civil code, we have the three-tier hierarchy structure here. It is the dispute commission, the state commission, the national commission. And to a perk, we have, even if the consumer is not satisfied by the judgment of the national commission, we can approach the Supreme Court. Whereas the objective of the consumer council is something that is really catchy and also very much essential for the effective functioning of the council. It is the speedy and effective disposal of the cases. What is speedy and effective disposal of the cases? As we all know, civil cases are clogged up in India. There are so many cases and we are very much sure that if we are going to file a complaint today, our judgment day would be maybe after some 30 or 40 years at times. So, but in consumer cases, in a few judgments, it's clearly mentioned, not in the judgments, after the order is passed, it is clearly mentioned how many days will it take for this case to be disposed of. The next thing is, Consumer Protection Act does not completely abide by the Civil Procedure Code. As it is a quasi-judicial code, now it is very much evident that the procedures aren't the same and they are shortened up to provide speedy justice to the people. This makes it completely different and supports the objective of this consumer council. The next one is the As we have talked about the procedures getting shortened up and all those. Now the topic is about what about the evidences, what about the proceedings, how are they happening. So the evidences are collected in form of the affidavit, which is completely different from that of a civil court, and the proceedings are shortened up, yes. But does that mean that it does not provide any speedy justice? Yes, it does. So there is one exception to this proceeding, which is the cross-examination. So as I've been saying, it is speedy justice, shortening of the process, and how do you conduct a cross-examination in this? So to stand to the objective, cross-examinations are also done only in the cases where it is very much necessary, like the case of medical negligence, where it is not about the credibility of the witness, but it is about the subjectivity and the fact of the evidence that has been submitted. Only in such cases, cross-examination are allowed. In the other cases, it is about the insurance and also about the cases which holds the highest monetary levels, where it is about not about the credibility of the fact, but it is about much more than what we can write it on the affidavit and much more. So it is done through ways like through affidavit. The council sends some interrogatories, and by oath by the council, before the council, and by video conferencing, which is a very good amendment that was brought in the 2019 Act, which gives space to technology and also eases the proceedings and other things. And then another place, a few consumers might not be like very much, they might not have, they wouldn't be comfortable enough to go approach court, where we still have the stigma saying even this day that approaching court is when you do a mistake. This is also because of the lack of awareness that people have. So I would like to conclude it by saying that Consumer Protection Act is indeed distinct and contributes to distinguish itself as quasi-judicial body, and these distinct features are very much kind of exceptions, and the exception that I have added here is the cross-examination, which is very much vital as I mentioned in the medical cases and other such cases which holds the highest monetary levels.
Good morning once again. I welcome all our venerated guests for the second session of the day, and we will be having a presentation today of our students, and I want the complete support from our end to support your friends who is going to be present here today, right? Thank you. We will begin with the paper presentation. However, due to the paucity of the time, I would request each speaker to kindly limit their respective presentation within 5 minutes. Is it clear, presenters? Right. So let's cheer it up for the first presenter, who is Niharika Jitendra Bratra. Presenter of the day is Ritisha.
Today my research topic is about rural consumer awareness. You know, every consumer, as a matter of fact, every citizen should be aware of the rural of their own rights to avail them. This study is to analyze the awareness of consumers restricting to a certain rural area to know their knowledge on their rights. Around 68.8% of Indian population consists of rural people, which makes India the largest rural population. Here, the aggregate part of Indian GDP is also the contribution of rural Indians through their agriculture, self-employment, services and construction, etc. Hence, the government has the responsibility to take care of their needs and necessities, also safeguard their rights and responsibilities. Here, they should not be neglected because of the globalization and all. Even the Constitution of India and the Consumer Protection Act is very well defined and documented to protect the consumer rights against the unfair trade practices. However, we can see many such unfair trade practices happening in our day-to-day life around us, but take no legal action because of that. Here, going to the research questions, the questions are rural consumers completely aware of their rights? Also, did the government succeed in educating the consumers, rural consumers about their rights and things? Going to the main hypothesis, there is no such imbalance in consumer awareness among the consumers based on their geographic and demographic factors. So, before going for the analysis of the part, the consumer disputes, the government consumer dispute we can see in India is about the low qualified seeds and fertilizers selling to the farmers, and also the unreasonable rates of the substandard ones. Farmers are the backbone of the India, should not be mistreated or broken in any way. Even after government taking such measures like providing electricity and water to some extent for free, also regulating the unfair trade practices of unfair trades, it is still failing up to put up the farmer suicides. Somewhere we can see that the government which is establishing the laws at the top is lacking while implementing them on the ground. Before going to the analysis, the first table shows the classification of the residents of 120 samplings which have collected from a village, Potladurti in Andhra Pradesh. Here we can see that the residents are classified in various factors like age, gender, education, occupation, and also income. Going for the next topic here, consumer awareness. We asked the samplings of the things like there are also people who are moderately aware of the rights like right to safety, right to be informed, right to be right to be heard, also right to be consumer education. But right to seek redressal is not as much as aware of the people like the other rights. Going for the main awareness, this has the similar report reviews, because the consumer awareness towards the Consumer Act and also the consumer awareness towards the government programs to which increases the consumer protection is actually similar with each other, with very large people partially aware of it and moderate people are fully aware of it, while there are also considerate amount of people who are not aware of it yet, leading to the conclusion the extent of consumer lack of awareness is completely seen in the given results. Also, even if the people are completely aware of it, there was no one such person who actually filed a case in consumer protection or tried to avail their rights in it, even after facing the unfair trades about them. There are also few people who are aware of the awareness program, but yet not very keen to understand the program or about the act which is for their own welfare. This can also be said as boldly that there is a negligence from both the parties. Also, they should be educated and trained towards their own welfare, also injustice they might be facing in future or in the past. Even the manufacturers, so the local traders should also be educated about this and also try to improve the others in their own limit, which would also benefit them in some or another way. Also, this would create a certain impact on the people who will come forward to fight the injustice happening against them, as we all believe their welfare is society's welfare. Thank you.
Am I audible to everyone? Right. So, good morning everyone. My name is Jishnu Venkatraman, and the title of my paper is Consumer Protection and the Legal Profession, an Analysis and the Way Forward. So I'll just very quickly go to my scope and objectives. The scope of my paper is limited to liability of legal professionals, and when I say legal professionals, I am emphasizing on advocates, and the analysis that is present in the study is limited to various courts' interpretations of service under Section 2, Clause 1, Subclause O of the 1986 Act and Section 2, Clause 42 of the 2019 Act. I have two main questions in this study. The first one examines the current legal situation in our Indian legal system regarding legal liability. And the second one examines potential ramifications of hypothetically including legal liability under the ambit of the CPA. Now I'll just jump into my judgments very quickly due to paucity of time. First, the LDA was N.K. Gupta lays down three parts of service as defined under section 2, clause 1, subclause O of the Act. As the inclusionary part, the main part, and the exclusionary clause. The last of which is quite specific. And two exceptions of note for the purposes of this paper is services that are rendered for free and contract of personal service. The contract of and for service is explained by the Supreme Court in IMA versus Shanta, showing that the parliamentarian was very well aware of this difference between the two terms and deliberately chose to include contract of personal service as an exception. Next, in K. Rangasamy versus Javadar, one of the first cases that are extremely relevant to my study, ruled that it is indeed the services provided by a legal professional is indeed a contract of personal service, which was challenged in Srimati versus Union of India, where the Madras High Court said otherwise. This was later reaffirmed in D.K. Gandhi versus M. Mathias, where it was held that all professionals, lawyers included, fall under the ambit of the CPA. Finally, when the matter was brought towards the Supreme Court, there was a preliminary ruling that ruled that advocates cannot be tried under consumer courts at the moment. A final ruling is awaited. Now, I will be exploring the potential ramifications of hypothetically including the liability of advocates under the CPA. First, the test of reasonableness. The term a reasonable man is, the legal profession is unaware of such a term. So it can be really hard to identify what's reasonable and what's not using the test of reasonableness. The second one of my main arguments, is that requisite knowledge is absent. I'd like to illustrate this with the help of an example. So let's say you hire a plumber to repair a leaky pipe in your house. When the plumber executes his services, the reasonable man possesses the requisite knowledge to ascertain whether the services rendered by the plumber are deficient, faulty, or otherwise, or proper. However, when it comes to cases involving advocates, the reasonable, normal, prudent man does not possess the vast requisite legal knowledge to ascertain whether an act or omission of an act on part of the advocate constitutes, say, deficient service or professional misconduct. Next, bringing the service of advocates under the CPA greatly restricts legal thinking, but now, because now there is a burden on the advocate to ensure that he plays it safe to avoid persecution from the client. And this would greatly restrict legal thinking and innovation in the field. Yeah, so based on these arguments, my finding is that ideally it would be preferred if the legal profession was not brought under the CPA. Thank you.
Guys, a big round of applause for the one-man army here.
As to the Kilpar and Alliance University for inviting me here and sharing my experience, what I learned during heading this consumer chair. And I'm making my presentation in two parts. First one, story of Consumer Protection Act 2019, which is not in any book that I know personally, so that I will share. Second one, how students can use Consumer Protection Act to improve your professional skills during your 5 years or 3 years course in your university, and also how you can help the needy people of the society. So these are the two parts I am taking. Before that, I appreciate the presenters, all the presenters. If you don't mind, all the students can stand up and give them claps. All the students stand up and give the claps to who have presented. Good, sit down. Because it's a lunch time, everybody may be hungry, a little bit standing up is better. And out of, I observed in the list 12 members presented, and it's a gender injustice in the presentation. 2 boys and rest 10 girls. I know that boys are generous, maybe they are helping those 10 girls. But in future, it should be shifting. Then, Consumer Chair is established by Government of India, Minister of Consumer Affairs, Government of India. First time in Indian history. It's a think tank and advisor to the Minister of Consumer Affairs, Government of India. And since 2008, I'm heading this chair. I'm advising the central ministry as well as state consumer ministry. And when we started in 2010, we wanted to amend 86 Act. Loopholes were there, e-commerce entered, the ministry thought of, let us amend the existed 86 Act. And we prepared a bill also in 2011 once and 13 once. It was a Congress government time. Sharad Pawar was cabinet minister, and George from Kerala, state minister. So we prepared a bill, but during that time in 2014 election happened and BJP government came. And BJP government thought of Ram Vilas Paswan. He was a cabinet minister, and thought of instead of amending all the sections, let us come out with a new legislation. So then we started working on Consumer Protection Act bill, which will be replacing the 86 Act. So that was the first bill, Consumer Protection Bill 2015. So this was introduced in Lok Sabha, and immediately it was referred to Parliamentary Standing Committee. So Parliamentary Standing Committee contains around 20-25 MPs of all the parties. MPs of all the parties together, one senior most person will be chairing, and they invited all the experts throughout India, all the stakeholders, all FICCI, CII, ASCOM, the Consumer Ministry secretaries, and NGOs, everybody they invited to Parliament. I also went and gave my expert opinion. In Google, you can get this particular parliamentary committee report also. So during that time, there were 2 national surveys done. One is Cuts International NGO from Jaipur. They did a national survey funded by Government of India. And second one is IIP, Indian Institute of Public Administration, New Delhi. They also did a national survey. Those were the base for us where we are lacking, how to improve the Consumer Protection Act. So these are the 2 national surveys. Then in one of the cases, UP Consumer Bar Council case, which went to Supreme Court, and Chief Justice of India constituted a committee under the chairmanship of Justice Arjit Pashaya in 2016. And this committee visited all the states, observed how state commissions are working, how district commissions are working. So those observations they submitted to the Supreme Court, and Supreme Court, keeping pending case, that particular case, they directed the central government to constitute an expert committee to frame a rules for appointment of these members and president, which was happening, political appointments. Then central government constituted a committee, and I was also one among them. We framed a rules and submitted to the Supreme Court, and Supreme Court sent to all the chief secretaries of all the states to implement within 6 months. But majority not done it. And meanwhile, we came out with the Consumer Protection Bill 2018. And again in 2018, election announced, and that bill lapsed. Then 2019 Act came, bill introduced, and it was notified in August 2019, and completely enforced in July 2020. So when it was introduced in 2019, if you look into the section 1 extent, it is applicable whole of India except Jammu and Kashmir, because during that time also the removal of that special recognition to Jammu and Kashmir was introduced. That's why it was there. Then later, once that the special recognition to Jammu and Kashmir was removed, now this Consumer Protection Act 2019 applicable to even Jammu and Kashmir. And another issue was happened, what about pecuniary jurisdiction increased? Lot of changes has happened, but pecuniary jurisdiction, whatever cases pending before the district commission, state commission, national commission, they should continue in the same commission. They should not be, because pecuniary jurisdiction is increased, then state commission cases should not be transferred to district commission. Only from the date of July 2020, later prospective cases should be as per the pecuniary jurisdiction. So that was the situation. And the major changes, maybe you have already studied, 4 new chapters came which were not in the 86 Act. First one, Central Consumer Protection Authority. Second one, mediation chapter. Third one, product liability chapter. Fourth one, offences and penalty. And the rest of the other sections changed a little bit, strengthened from 86 to 2019. And mediation chapter, why we have we discuss literally, committee discuss section wise. So why this section should be, chapter should be added. When before introducing the mediation, central government requested the consumer chair to start online consumer mediation center at National Law School. We, as a pilot project, we started in 2016 to 18. And during that time, we concentrated only disputes between e-consumer and e-commerce companies. So only those cases we handled. Amazon, Flipkart, all these higher up officers came and discussed with us. But at the end they said, this mediation under 1986 Act is not recognized. We are not interested to come for the settlement through mediation. Then I submitted reports of all these challenges to ministry. Then we thought of adding this particular mediation chapter under the new act. And also, if you look into the 2 national surveys, only 0.3% of the aggrieved consumers are approaching consumer commission. 0.3%. Rest of them are not approaching anyway to the seller, especially 94.8% of the people, even though they are literate, they are not approaching any commission or any seller or ombudsman to get the justice. So we looked into all those things. That's why we added online filing of the cases, e-dakil, then online payment of the fees, video conferencing. All these things are recognized because busy people may not go to commission and file a case to get the justice. So all those things, even the lot of time spent in the serving of the notice. So now email is also recognized, electronic mode methods are also recognized. So these are the aspects. And also why people are not filing the case, because of the territorial jurisdiction. Territorial jurisdiction where opposite party reside, works for gain, where cause of action partially or fully. And if I went to Delhi and purchased the goods and it's a defective, I cannot go to Delhi and file a case. So that's why I suggested, let us add in that where consumer is residing and works for gain. Lot of objections came from these business people. But ultimately I said, this act is for the welfare of the weaker section. Weaker section is a consumer. You should add, and other legislations are also having the same provision. Then at the end, they convinced and they added, now wherever consumer is residing, works for gain, so that is recognized. So these are the some of the aspects, e-commerce rules, direct selling, then pecuniary jurisdiction is increased, territorial jurisdiction is expanded, and the online filing of the payment or filing of the cases, video conferencing, endorses liability. And when we added endorses liability, lot of objections came from film industry. And when it was introduced in Rajya Sabha, lot of objection from one MP. who is that person? Anybody expect? Who is that person in Rajya Sabha objected? Jaya Bachchan. Because in Maggie case, notices are served to the Amitabh Bachchan and Madhuri Dixit. So she objected, and you can see video is also on the Google, you can get it. Ram Vilas Paswan, ma'am, he mentioned, we are the fans of Amitabh Bachchan and you also, but at the same time you have a responsibility towards the society, because public will trust you, believe you, whatever you say, they will accept that it's the truth. So that's why you should have a responsibility. Now, CCPA, Central Authority, has a power to impose fine. Even under the Commission can also do. Even Central Authority can impose fine. And if they continue, even 2 years, they can prohibit from doing commercial advertisement. That is a high hit for them. So now everybody is careful. Recently, Baiju, some of the officers came and discussing with us. Nowadays, nobody is coming to give advertisement. We are searching for actor and actress. Because of this risk, now they understood whatever they want to do, they should know, is it a truth or false? If it is a truth, what is the documents, what is the support to what they are saying, tall claims. So these are the aspects they looked into. This is about the story of how we brought this Consumer Protection Act 2019. Coming to your point, so how students, you are in first year, this Consumer Protection Act is enacted for the layman. You are better than layman. So when act is enacted for the layman, you are better than layman, why not you can make use of this legislation? Who can stop you? Wherever injustice happens to you or your relative or your friend, why not you can represent yourself before the commission? And these are some examples I am showing. National Law School students filed a case against Pepsi. How I told you how students can help the society, how you can get the professional skills during your law course. And as a student, as a faculty, as an institution, we have a duty towards society. And always our founder director, Professor Madhav Menon, who started National Law School, always he said, he has not mentioned legal education, always he mentioned justice education. Means law, through this particular education, we want to give justice to the needy people. So that is the idea of starting the law school. So while doing, see, you are sitting in a class, in an institution, you are learning the subject in a class, but unless you understand how society works, ultimately you have to apply these laws to the society, to the context, so that you will learn when you connect to the society, connect to the public. So that is the idea of the thing. And always, this is a common statement usually put in every commercial, the buildings, but nobody obey or go as per this. So always it's nothing but justice, consumer is a king. And it is not a new to India, only after 86 or after constitution. Even why we brought Consumer Protection Act 86 and 2019 or any other welfare legislation, because constitution tells the article 21, right to life with dignity means right to life without exploitation. So for that purpose, all these provisions, and in Manu and other documents also you will get Kautilya's Arthashastra, one particular chapter independently discussing on removal of thorn chapter. During that time also exploitation was there. So Article 19(1)(g), yes, it's a fundamental right given to anybody can start trade and business, but it's not an absolute fundamental right. So state can impose reasonable restrictions on these business and trade. That power is given under Article 19 Clause 6. That's why state is coming out with the consumer welfare legislations to protect the consumer. And Article 21, what I said, right to life without exploitation. And two directive principles, Article 38 and 39, state to secure a social order for promotion of welfare of the people, and 47, duty of the state to raise the level of nutrition and standard of living and to improve public health. So all these together puts a duty on the state to protect the consumer. So I told you the Kurtz International Survey, 0.3% of the aggrieved consumers are approaching Consumer Commission. And 93.4%, they are not approaching anyway, seller or company or sector ombudsman. Do you think that 93.4% of the public in India are illiterate? No. Literate people are also there. They think that it's a waste of time, waste of money. Why I should start? Let others start. If they get it, fruit will come to me. That type of attitude in Indian consumer mindset. So that has to go. So other reasons are, yes, maybe delay is happening. That's why under 2019 Act, we removed those the reasons for delay, the digital e-filing, e-payment, video conferencing, all those things we brought. And these things I discussed with you already, background of CPA, that is the state of UP versus all UP Consumer Bar Association, 2016 judgment, Justice Ajit Prasad Committee. Then now presently there is a case pending before the Supreme Court in inaction of the governments in appointing president and members, staff of the districts and state commissions and inadequate infrastructure across India versus Union of India. You may not hear this type of title of the case itself. This is the title of the case. Here you can, I mean, this is a suo motu writ petition. Actually, complaint was filed by law student in Delhi and it is converted to PIL. So here, sometimes the judicial activism is needed. Keeping that case pending, the Supreme Court is asking, getting information. As per the new Act, 2019 Act, members and presidents are appointed or not. The information will, the Supreme Court ask the all the information from all the states. So all the states submitted the report. Majority of them have not appointed. Then next hearing, directions. Within 3 months, you have to appoint these members and president. Then they obeyed. Some of the states not obeyed. Then next hearing, observations are made to those states. You are not submitted, it's unfair, do it. So immediately, no state wants to go against the Supreme Court, so they obeyed those things. Next hearing, under the Consumer Protection Act, mediation cell should be established at the district level, state level, national level. Is it established? So again, getting information. Majority of the states not established. Again, direction. Within 3 months, you have to establish mediation cells. And even central government funding, I mean, the Minister of Consumer Affairs sent a letter to chief secretaries of all the states. We want to fund you to establish a mediation cell. What may be the cost? Then chief secretary sends to president of state commission. President of state commission sends to all the district commission. Do you have a infrastructure? If you have, do you have a furniture? If you don't have anything, ultimately what is the total cost if you want to start a mediation cell? Then they have to submit the cost and collecting all the things. Commission has to submit to the chief secretary and chief secretary sends to the Central Ministry of Consumer Affairs. They are funding. So that is the way how it works. And some of the things what I observed, nowadays Prime Minister portal is very active and very strong. And one of the senior citizens filed a complaint on the PM portal. My case is pending since 12 years in Bangalore District Consumer Commission. It is not heard, not given the decision. So it went to the PM office. From PM office, it is referred to the Ram Vilas Paswan. From Ram Vilas Paswan, it came to the Secretary Minister of Consumer Affairs, then to the Joint Secretary. This case was pending in Bangalore, then Joint Secretary sent it to me. See that this case is pending in Bangalore District Commission, see that it can be disposed of. Then I met the Registrar State Commission, requested on merit, we are not influencing this side or that side. On merit, you have to dispose of the case. Kindly direct that District Commission President. So they directed within a week it was disposed of. Reverse report went up to PM office. So that is the way sometimes how it works. So these are the aspects. And one of the Supreme Court case, constitutional bench said access to justice is a fundamental right. And how to achieve this access to justice? There are four essential elements. One is effective adjudicatory mechanism. Second one, reasonable, accessible in terms of distance. Third one must be speedy. Fourth one, it must be affordable. Then only we can say that it is access to justice is given to the people. These things can be achieved under the Consumer Protection Act. Up to 5 lakh rupees, no court fee. Up to 5 lakh. If you see, usually we know that being a student, pocket money given by the parents, that itself is always, it's not sufficient. During that time, file a case, pay the court fee, it is impossible, it's very difficult. So up to 5 lakh rupees you are claimed before the district commission, there is no need for you to pay any court fee. And it is in a district commission, in your district place it is situated, and under the new act also it is directed, district commission can sit even in taluka place. If that taluka is having a more number of cases, they can go and sit in taluka place and hear the matter. Even state commission can go to the other side of the state, can sit and hear the matter. So that is also allowed. And it's a summary proceedings, and along with the retired district judge or serving retired district judge or qualified to be district judge, 2 social workers are sitting with them. So social workers, because they know the grassroots level problem, they can understand the problem of the consumer. So those are the aspects. And always it's the act itself, consumer protection. It is the legislation. Always if a layman is expecting to the consumer commission, if you don't know, then it is the duty of the commission to educate that person. If something wrongly he written and submitted, and then the commission should tell him that this is wrong, you have to write like this. They cannot reject without any valid reason. And even sometimes it was delay was happening, then they said within a month if it is not admitted, deemed to be admitted. So that provision is also made under the new act. So these are the chapters 107 and 4 new chapters. One thing in miscellaneous chapter, this time we added one particular provision. In every act, state powers to make a rules, central government powers to make a rules. So in state can make a rules. In that one provision, clause we added, if you see in the miscellaneous chapter, what is that? What we observed under the 86 Act, all these rules framed by the state governments, all are different. There is no uniformity among the states. So that's why what we thought, let us keep uniformity. If there some states have not come out with the rules also. So if state government has not made a rules, then if central government has made a rules, those rules are applicable until state government makes a rules. If state government wants to make a rules, then compatible to the central made rules. So that way we can bring the uniformity throughout India. Even salary of the district commission and state commission members was different. During Congress government time, the Mr. George of Kerala was a state minister. So because of him, the 50,000 was then the salary for the district commission members. In other states, Karnataka 20,000, in other states 30,000, like that, the no uniformity. That's why under the new act, under the rules we have framed, actually they wanted to fix the amount. Then I said, if you fix the amount, today this amount may be bigger. After 5 years, that amount will come down because of the inflation. So instead of fixing the amount, fix the cadre. So we said state commission member's salary should be deputy secretary of that state, and district commission member salary should be deputy director's salary. So whatever changes happens to that person in that state, automatically it shifts to these members. So those are the things done. These are the rules framed. And why you are studying Consumer Protection Act under law of torts? why Bar Council of India included Consumer Protection Act and Motor Vehicle Act with the law of torts. In National Law School, we teach independent, tort 1, tort 2, tort 2, completely all consumer welfare legislation. In that, we teach Consumer Protection Act, Drugs and Cosmetics Act, Bureau of Indian Standards Act, Food Safety and Standard Act, Legal Metrology Act, all ombudsman, all regulatory authority, consumer centric, not everything. So here why BCI has included, BCI because law of tort is not developed in India. We read and understand, but ultimately give example law of torts case in India. So you will not get a cases except Bhopal gas tragedy case where absolute liability principle has come out. But other way it's a very rare. But all those, it's a uncodified law. So all names, the hostel room numbers are given, room number 2006 Ganga Hostel National Law School. All these students filed a first wherever unfair trade practice is happening, you can identify and do research on that, then later send a notice to them. So here in classroom you are studying subject, but if you connect that subject to your society surrounding, then you will get an interest, you will enjoy the subject. So that's why whichever subject you are studying, connect to your surroundings and involve yourself. Then there is no need for you to by heart anything. Just it will print in your mind, and your answers are different from other answers because other answers are depending on what textbook written. So that's why always the evaluator wants to search what is the new thing he has written which is not there in the textbook. So that way it is very helpful and you will enjoy what you will learn here. What are the professional skills once you complete your LLB degree you should have? First thing, you should have a good drafting skill, argument skill, and how to handle the people, how to handle the judge, how to handle the client, how to handle the opposite party advocate. These are the things, major skills you should learn before entering into the profession. That provision or that opportunity you will get under the Consumer Protection Act. And why you are saying we are first year, we don't have studied any laws, how you can say that we can handle? Because we know that what are the problems in the regular court. All those problems are removed and we brought this Consumer Protection Act. What are those problems? We have to apply Civil Procedure Code 1908, which is complicated, even advocates may not understand sometimes. So that particular Civil Procedure Code is not applicable here. Evidence Act is not applicable. So when complicated procedures are not applicable and it is a simple summary procedure, it is easy for you even you are in first year. So that's why you should make use of it. And through doing research, first thing you are taking a product, doing research, how to do research, that you will get first hand information. Second, before filing a case, you have to send a notice, you have to draft the notice, drafting skill, drafting of notice. Then if they are not answering, then you have to file a complaint, drafting of the complaint skill. Then you are going to Consumer Commission, you yourself is filing, then how to handle the bench clerk, how to pay the fees, court fee, how to, all those things you yourself will learn first hand. That will help you once you enter the profession. So after entering the profession, you cannot spend, there is no need for you to spend another 5 years to learn these things. Then revenue starts. So why not you study or get these professional skills during these 5 years. Once you enter, let us get a revenue, get a case and you are capable to handle the cases and you start even independent from your family financial assistance. So these are the skills you can learn in the law school itself. So this is a one case, and when the students themselves filed this case, and students Aditya Banawar, he himself argued the matter, and opposite party is Mantri Mall, and when we filed a case and we won the case, and immediately opposite party is a Pepsi, big company, immediately they hired Udayawalla for appeal. So immediately he took presented before the Karnataka State Consumer Commission and took a stay order. So it was a case of they handled maybe around 10 years to drag the case. When case is weak, advocate feel, better it is drag the case. Whenever it comes, let us see. So this case was, then they filed an appeal, and after 10 years, see, Consumer Commission, what it says, within 3 months from the date of notice served to the opposite party, if lab test is needed, 5 months. But here 10 years. That is the thing we are concentrating now from the central ministry also, and everybody concentrating how to solve this. So in this particular case, ultimately this case also we won, students won this appeal also. And this is the one, see how, I don't know, Upendra Bakshi got this particular cases. So he wrote a article on these two cases, Pepsi case. So he has written in this who have filed the case, all the details in his article, and even he has discussed how consumer chair is working at National Law School. He appreciated. So this is the way how always whenever students represent the public cause case before the High Court or anywhere, always judges will encourage you because you are helping the society. So this is one way. And another case which we filed, that is a PIL. This is a PIL filed by the students, public interest litigation in 2014. So during that time, around 60 to 70% of the Consumer Commission members were not appointed, presidents were not appointed, 3 new districts were formed, district commissions was not there. And students, through empirical research, they collected the data and prepared a report. And I personally, along with students, met Principal Secretary, Government of Karnataka, Minister of Consumer Affairs, discussed 1 hour to implement this particular thing. In Karnataka, consumers are suffering. After 1 hour discussion, the bureaucrat said, we are busy in other work, we don't have a time to do this. Then we cannot quarrel with them, came out, discussed with the students, then we filed a PIL, public interest litigation, before Karnataka High Court. It went before the Chief Justice of Karnataka, and notices are served to the opposite party. We made Chief Secretary, Government of Karnataka, then Consumer Ministry Secretary, and the President of State Commission. All 3 were the members. And then third hearing, they ordered, you have to implement, you have to appoint all these members within 6 months. Who said no to me? The same person appointed all these members, established 3 district commission. That is the power of the students. So wherever you go, the appreciation will be there, the recognition will be there. And like that, even juvenile justice, under that also it has happened. And these, whatever, whenever students goes to the commission or court, always media will encourage you, motivate you to come out with these types of news in that. Yeah. So these are some of the in newspaper, it a High Court notice on vacancies in Consumer Forum. During that time, they came out with how many pendency of the cases, what state government is doing, PIL is filed against the state government. So all the newspaper covered about the PIL, about the cases. Law students fight false advertisement. This is one. Again, they identified cosmetics and which tall claims are wrong, which are not true, and they purchased themselves those cosmetics. As per the direction, they applied on themselves, and after 2 months, nothing is changed. Then they drafted a notice and sent a notice to so-called all multinational companies, and some of the companies replied, we are giving you gift hamper, kindly stop here itself, and some of them not replied. So then the students went to District Consumer Commission and filed the case. So there they were not knowing how to file a case, where to go, affidavit should be attached, all those things. By going there they learned what is lacking, they improved. And bench clerk was not ready to admit the case, take the case. Then I said, they came back to me, sir, they are saying not to, it is not maintainable. Then I said, this is a book, Act, Rules, Regulation, convince. So there nobody is above these rules and regulations. Then they convinced, filed it, and they want to give by cash the court fee. No, you should go to bank, file it, pay there and bring challenge. How many opposite parties, how that many sets you have to bring, and you should learn how to stitch the file. So all those things you learn during your the LLB degree itself. So all these things they learned. So these are the some of the things, and other aspect, just I will take you to the, okay, how much time I left? And then, okay, right.
And informative session. I'm sure apart from your theoretical legal knowledge, your practical knowledge has also been enhanced today. All thanks to Dr. Ashok R. Patil. I thank you, sir, and all the other guests for this technical session. 1 comes to an end. We will now break for lunch, and after lunch at 1:30 we meet again for technical session 2. Thank you, everyone.
Autometers are governed by which law? Who is, which department authenticate this meter is a good meter? Legal Metrology Department. Legal Metrology, earlier it was called Weights and Measures. Legal Metrology Department. It is in Ali Asgar Road, you can visit. So Legal Metrology Department, there auto inspectors are there. How do you know that 1 liter petrol is 1 liter? So that measuring, always it's the duty of the all petrol bunk, 5 liter measured, authenticated, that utensil should be there. So this numbering 1 liter, 2 liter, that machine is also authenticated by the Legal Metrology. All weights and measures. It was earlier called Weights and Measures Act, now in 2006 Legal Metrology Act. So Legal Metrology Department, they will authenticate. So now autometer is there. How do you come to know that, being a law student, is it certified by the Legal Metrology Department? Anybody check? Autometer is there. Have you checked surrounded, what is there behind? It is just in front of you. So there is a tag. Yeah. This is this much small. All those things may not be written on that metal. Metal, maybe it is one alphabet, A or B or C or D, one of the alphabet. Next, the 2 numbers, 22, 21, 20. So what it means, it was certified in the year 2022. A, B, C, D, what? 12 months divided into 4. A means first 4 months. So that way you can identify that it is authenticated in which year. Every year, depending on the machines, it has to be authenticated by these departments. And why you, maybe girls, you have visited a gold shop, and weaving machine is kept in a glass box. And if it is not kept in glass box, you should tell that, because even fan pressure will vary, even 1 gram variation in 1000 rupees. So they have to keep all those things as per the legal methodology. Again, my question, you went to cloth shop, 1 meter cloth. You have taken 1 meter cloth. 1 mm is less. 1 millimeter small or 2 millimeter is a short. 1 meter cloth. Is it a defective product?
No.
Yes. So it's a shortcoming is there. Do you expect 1 kg sugar if you purchase perfectly 1 kg? Even 1 gram may be less. It is a defective. So again, under Legal Metrology Act, there is a rules permissible error, depending on the product. 0.1 if it is a sugar, if it is a 1 milligram here and lesser or more, it's considered as a correct. Even in 1 liter petrol, if 1 ml is less, it is considered. These mischievous people, they fit it like that lesser only, which is permissible error. Whole day, if they do it, so again through that also profit they take. So again, it is mentioned under the Legal Metrology Act. So this is a way you have to, whatever you are seeing or traveling, you look into that and get the experience. And service definition we have discussed, medical service or advocate service, and section 2 of the Consumer Protection Act, no exclusions are there. If you look into, very important judgment is Lucknow Development Authority judgment. They have clearly mentioned that intention of the legislator is to cover state government, central government, whosoever, if they fall under consumer definition, they are covered. So, especially Lucknow Development Authority, they said, I am a sovereign, I am established under the state, under the act, I should not be held liable. No way. What Supreme Court said, you are more accountable to the society because you are for the society. Don't try to escape from the law. That is the way how they observed in that Lucknow Development Authority. Very sad that some of the judgment I am not agree with the Bihar Examination Board case, many cases now case pending before the Supreme Court, even advocate, see advocate case, Gandhi case, they are managing to postpone. If it is decided 100% it says you are coming under Consumer Protection Act, better drag the case. So that is the way how it works. So here service definition, especially in 2018 bill, here in the service definition, health service was added. I am talking about Consumer Protection Bill 2018. Health service was added. In 2019 bill, health service word was dropped from this service definition. Is it a difference adding and removing? Now health service example is not here. So it means health service is not covered under the Consumer Protection Act. Health service word is not there. Whatever words are there, financing, insurance, transport, processing, only those things are covered under Consumer Protection Act. That is the argument.
No, sir, that's not true. Health services is still covered under.
So how do you prove under this act with this particular definition?
But not limited.
Yeah. So it includes but not limited to means this definition is not an exhaustive definition. It is an inclusive definition. In this definition, all the services you cannot give. Some examples are given, rest of the others are also covered. So immediately when that was removed from 2018 bill to 2019 bill, Indian Medical Council, they put up a notice in social media, thanks to Prime Minister for removing medical services from Consumer Protection Act. They don't know that removing or adding nothing will change. Under 86 Act also it was covered, now also it is covered. So new, the unfair contract definition is added. And another thing, if nowadays bills are not given, sometimes bill, if you purchase somewhere, bill is not given. Can you go to Consumer Commission file a case when there is no evidence? when there is no evidence, bill is not with you. They say that you have not taken from my shop. Can you file consumer complaint against the seller? So this is a 2019 Act, Section 247, Unfair Trade Practice. Last 3 clauses are added. First clause, not issuing a bill or cash memo or receipt for the goods sold or services rendered in such a manner as may be prescribed is also considered as an unfair trade practice. But how do you prove? Yes, law says, but ultimately you have to prove before the court. If the commission, opposite party says he is telling lie, how do you prove? So whenever these receipts are not given, some other supportive documents you have to create. How do you create? You can take a shop photo or record, or if they have a email, immediately send an email saying that it's a defective and you are not refusing, or send a WhatsApp. Some evidence should be there. Without that, commission may not admit. Not bill, but any other supportive, or you can say corroborative evidence. So electronic service provider, video conferencing is allowed, e-commerce, electronic service provider. This is very, very important. You should go through the duties of recently last week we have a discussion with Amazon with some of the consumer experts. So we discussed how nowadays the ministry is working on 3 new aspects. One is fallback liability principle. The Amazon is saying, I'm just a platform, I'm not a seller. If anybody comes on my platform, sells, if it is a defective, you cannot file a case against me. They are saying, but it is not accepted. You are not doing a charity. Amazon, you are not doing a charity. Every year profit is increasing. You are taking commission from the seller. So you are not expressly not mentioned under the rules. Now we are bringing that clause, fallback liability. You should see that seller should satisfy. If it is not, you are responsible. So that clause. Second one, we brought already, Bureau of Indian Standard came out with a IS number on fake review, online review. Already they brought, because if you see on the website, so those things, just I will not go into these things. I will show you. You can even involve yourself. Some of the you can put in your just
पूरा प्रोजेक्ट बचा हुआ है और ये मैंने यूएस में रेटिंग किया
तो ये सेम चीज आपके साथ भी हुआ ही होगा कभी ना कभी। एक सर्वे में पाया गया है कि 84% ऑफ कंज्यूमर्स मेरे और आपके जैसे लोग रिव्यू पढ़कर ही सामान खरीदते हैं और 68% तो ये तक माना है कि जितनी ज़्यादा रेटिंग रहेगी उतनी ज़्यादा रिलायबिलिटी रहती है प्रोडक्ट की। लेकिन क्या ये सारे रिव्यू जेन्युइन रहते हैं? ऑब्वियसली नहीं, और फेक रिव्यूज का बिजनेस बढ़ते ही जा रहा है, जैसे कि कई सारे न्यूज़पेपर रिपोर्ट्स में भी बताया गया है।
पर जब कंज्यूमर प्रोटेक्शन एक्ट है आपके साथ तो डरने की क्या बात। सेक्शन 2 सब क्लॉज 47 कंज्यूमर प्रोटेक्शन एक्ट 2019 और ई कॉमर्स रूल 2021 में ऐसे ही डिसेप्टिव प्रैक्टिसेस को रोकने के लिए प्रोविजंस बनाए गए हैं। अगर आप भी किसी सामान की रेटिंग्स को चेक करके कोई नया सामान लेते हैं लेकिन आपको पता चलता है कि उसकी रेटिंग फेक थी या आपको बाद में पता चलता है कि कमेंट्स पेड थे किसी भी तरह, तो आप डिस्ट्रिक्ट कमिश्नर को अप्रोच कर सकते हैं और उसके साथ में ही BIS ने नवंबर 2022 में एक नोटिफिकेशन भी जारी की है जिससे आपको पता चलता है कि फेक रिव्यू के बढ़ते बिजनेस को रोकने के लिए ये सब चीज समर्पित है और आप अपने राइट्स को इन्फोर्स कर सकते हैं।
तो कुना, अब तुम्हें पता है क्या करना है?
हाँ मेरे को पता है, मुझे प्रोजेक्ट बनाने दीजिए।
Yeah, only last one. Now dark pattern.
लिमिटेड टाइम डील चल रही है, 80,000 के शूज 8,000 में बस। मैंने ऐड किया, प्राइस 10,000 होता है, क्या लिमिटेड टाइम है, मैं भी ले लेता हूँ। अगर आप लहंगा
experience this, you'd become victim to Amazon's dark patterns. Dark patterns may range from signing you up for things you do not want, to making it difficult for you to opt out of a service, or to trick you into thinking that the product is priced at a lower price while it actually has other costs attached to it. Amazon is particularly notorious for its usage of dark patterns. The EU and the US have now started talking about dark patterns. Here is EU discussing dark patterns with Harry Brignall, a designer who first discovered the presence of dark patterns.
Design is mainly the science of persuasion and control. Gone are the days of designing things to...
And here is the United States. Those principles of common law system recognized under the statute, welfare legislation. One very good welfare legislation is Consumer Protection Act. So here, even though he is not a party in person, the other person can also file a complaint on behalf of the aggrieved person. Voluntary Consumer Association can file, central government and state government can file, one or more consumers together in case of death, legal aid, and even agent can, authorized agent can file, which is made under the rules. So here, central government and state government, even though power is there, but no majority of the states not used, and even central government used first time when Maggie case has come. So we prepared a report. You have a right under, this is unfair trade practice, misleading advertisement, you have a right under this provision, you yourself can file a complaint before National Commission. So first time central government, during Ramvilas Paswan, case was filed before the National Commission. Some cases filed in Tamil Nadu and other states, they have used it. So I will not go into the other definition. So the consumer definition only 86 and 2019 only change is the second B explanation clause is added. Do you think that now they have added buying goods or hiring service online or offline? Under 86 Act it was not covered, consumer definition. Under 86 Act, online purchase, e-consumer is not protected under Consumer Protection Act, under 86 Act. If you look into the definition, consumer means any person who buys any goods for consideration. Where it is mentioned physically purchase, buys any goods for consideration, that's all. It's a neutral, online or offline. It is covered. So many cases are there under 86 Act also. Online consumer, if he has suffered, cases are heard and judgment is given. Only that explanation is to layman may not understand this interpretation. That's why they expressed online or offline is there. Territorial jurisdiction, as I have mentioned, the last clause we have added under the 2019, which was not there under 86 Act. The complainant resides or personally works for gain was added. And this is a pecuniary jurisdiction. Earlier it was 20 lakh. Lot of discussion happened on this point. So actually it was up to 1 crore when the act was enacted. Later through amendment they reduced to 50 lakh. And here value of the goods, earlier under 86 Act, how you decide which the district commission should be filed. We used to decide value of the subject matter plus mental agony, whatever grounds all together. If value of the subject matter is the 10 lakh, other rest of the grounds we can add another 10 lakh, 20 lakh. On 20 lakh we used to decide the pecuniary jurisdiction of the commission. Now it is only on the value of the subject matter. For example, up to 50 lakh is a district commission. You have taken a 49 lakh car and it was repaired for repair purpose, another 10 lakh you have given mental agony, altogether you are asking 75 lakh rupees as a compensation. So where you will file? Where you will file, your claim is, total claim is 75 lakh, value of the subject matter is 49 lakh. Where you are filing as per this pecuniary jurisdiction? Where you are filing? The slide clearly discloses the answer. Where you are filing? district commission. District commission because value of the goods or services paid as a consideration, that is the point they are considering, not total claim. So value of the subject matter is 49 lakh. You should file before the district commission. District commission to entertain the case below 50 lakh. It will not stop district commission to award more than 50 lakh. It can award up to 75 lakh. It is only for admission of the complaint, the pecuniary jurisdiction, but 49 lakh case can be, the value of the subject matter can admit the case, if documents proves, then 75 lakh order can be made by the district commission. So that is the change of assessing or fixing the commission. So defect and deficiency, these are the two words, very important words. So defect and deficiency, what is a defect in food? What is a defect in electronic goods? What is a defect in other things? It will not tell you here. Same way about the services. What is the deficiency in insurance, banking, telecom? It will not tell you here. Only they are mentioning here. One of the thing is under any law for time being in force, mid part. Under any law for time being in force. It means there are special legislation sector wise. That sector is having a regulatory authority. That legislation or regulatory authority came out with the rules and regulations. What is standard? What is pure? What is, everything is prescribed. If it is not followed, then falls under the defect or deficiency. That's why you should know other legislation if it is a insurance case. So if you have filed a claim, but last 1 year they have not settled the claim, and one of the regulations, IRDA in bracket, protection of policyholders' interest, as per that, within 1 month you say reject it or accept it, you have to communicate. And also it says every month they are asking one document, and every month one document, 1 year it is dragging. These regulations says within 15 days, one time you give a list, all these documents are needed, not on piecemeal. Once they submit, within 15 days or 30 days you have to dispose of. So if you know the insurance regulations, then you bring under here the deficiency, here any law, under any law for time in force you connect. If it is a prima facie case in any of the things, that is okay, but otherwise you have to bring these legislation. For example, food, especially all of you like all varieties of junk food. Immediately it will not affect your health, but long run it will give you the result. But now you have a resistance, that's why nothing will happen. But usually all junk foods are having trans fat, which is very injurious to health. Under the Food Safety and Standard Act, it should not be more than 0.2%. And also many other things are there. But you, especially gobi manchuri, if it is a reddish color, you like more. Why it is too much reddish? Because they have put a color, more color. Color is injurious to health. So under the Food Safety and Standard Act rules and regulations, they have given how much color can be added, how much chemical can be added. They are adding more. Why your outside food is more tastier than your mother's food? Because they are putting all tasty chemicals, other things. In house, mother will not do that. But that's why that is not tasty. So this is the way how the business works. So under the Food Safety and Standard Act, if you check it, how much chemical, how much the color is added, so on that basis it will be decided. How much time, ma'am?
10 minutes.
Okay. So like that, now let us think outside the Alliance University there is a shop and you found one particular product, assume that food product, which is fungus packed product, which is expired, the expiry date will be there, or if they are asking more than MRP, what you will do? they are asking more than MRP, because if you take a cold drinks, no refrigerator electricity bill, if it is at 20 rupees, they will ask 22 rupees, and you pay that. So is it, then what is the meaning of MRP, maximum retail price? So MRP means you should not give more than that, but you pay. Assume that you are challenging that. So how you can handle, or if it is a defective fungus bread, or they are given packed one, or expiry date product is given, food product, how you are getting justice against that particular seller? He is not ready to replace, he is not ready to pay the amount. How you are getting justice? What is being a law student? How you will get a justice? You will fight with him? No, you cannot fight. Physical fight, but legal fight. How? Where you are approaching and wants to get a justice? Where you are approaching? Yes?
And then I go to an advocate, I say them all the things, he files a notice, I give the notice, in spite of the notice, if he doesn't respond me back, then I go file a case with the same notice and all the substantial evidences. I go file a complaint in the consumer.
Okay, so this is one way. Another way, it's the food product. Food Safety and Standard Act is a protecting act. Under that act, how you are getting justice? Under Food Safety and Standard Act. So this procedure, it takes time. Immediately you want to stop that, other people may suffer. What is the solution? Quick solution. Keep yourself in that place. Think. So, under the Food Safety and Standard Act, Bangalore, in this jurisdiction, who is an authorized person to take care of all these things? There is a food safety officer, food inspector, food safety officer. So, in government department, BBMP, or if it is falling under BBMP, there are food inspectors. So, you have to approach that person. Then he will visit and he will take a complaint and he will take action if you provide all these documents. Nowadays, in all the government departments, it's a very, all they say we are very busy, this, that. So once it has happened to me, I gave a complaint, nobody responded. Then I put up in a newspaper, immediately next day they came. Oh, sorry, like that. So it is a common thing in all the departments. We have to face those challenges. So that is another way you can approach those people and file. For example, I think everybody experienced auto rickshaw. If auto meter is tampered, same distance, good auto meter, so it gives you 100 rupees, tampered one 150. How you solve this injustice? Where you are approaching? See, day to day you are involved. So sitting and going in a auto rickshaw, that is okay, but you should think in different way. You are a law person. Don't think like a layman. Whatever you are doing, think differently. So where you are approaching? So he is not ready to, one is tampered one, and if it is 100 rupees, he is asking 150. Where you are approaching, how you are solving?
Guidance on dark patterns.
First of all, online ads that look like editorial content, hidden fees and charges that don't appear until late in the buying process, a free trial offer that leads to a recurring subscription charge.
Because of the deceptive and unfair means used by dark patterns to make sure consumers spend their money, usage of dark patterns by e-commerce platforms like Amazon is an unfair trade practice which the Consumer Protection Authority have to look into. Until that, consumers beware and think carefully from getting influenced by e-commerce platforms and their design. Thank you.
See, who can stop you to do this? Anyway, you like reels. You can do these types of reels and upload on social media. And if you do research, another thing, you have to do research. To file a consumer complaint, you should be a consumer. If you see these types of unfair trade practice, you do research, prepare a complaint and send through online to the central authority. That is enough. Central authority will admit your case. Only thing you have to prove that consumer as a class is affecting, not individual consumer. If it is there, then they will convert. Now they have taken a lot of action against these types of people. Ultimately, what I want to impress upon you, the youngsters, you have a energy, strength, help the society how much possible. With these words, I conclude. Thank you very much.
A very good morning to everybody present here. I'm Ritisha. I'm a first year student of BBLB of the Alliance School of Law. My topic for consumer protection is the dilemma of service charge. Dilemma, as we all know, is confusion. So the agenda of my presentation would be to introduce the meaning of the term service charge, move on to what problems I found with the term and how it's affecting consumers, and also tell you what I found out. So to introduce the subject, service charge, as we all know, is a charge or a tip or a gratuity that hotels and restaurants, mainly in the hospitality sector, charge a consumer. So I took a survey of where the scope was of 103 people who were from different professions and different economical statures. So I took people from professions of software, technical industry, and also chefs and people who work in the hospitality industry. And I made mainly 3 observations. One is that consumers are not aware of what the law or what the provisions of the law are for them. 2 is that even if there is a legislation that exists, the legislation is not strict enough for it to be applicable and for people to actually use the provisions that the law has presented to them. And the third is the restaurants or the hotels that actually these laws are applicable to, the validity and the applicability that they allow the consumers to profess. So coming to the first thing, as you can see, the question in the survey was if the consumer thought that service charge was mandatory. Like we all know, service tax and service charge are 2 different concepts. Service tax is levied by the government, whereas the service charge is levied by the restaurant or the hotel or the enterprise that we go to. So the question was if people thought that the payment of service charge was mandatory. Like you can see, the survey said, this is a sample space, I'm sure this has a limitation to it. So as you can see, 30% out of 100 people, which means 30 people out of 100 assume that they're mandated to pay service charge. So like Sir was mentioning in his inaugural speech that the 2019 Consumer Protection Act helped form the CCPA, which is Central Consumer Protection Authority. This authority released a set of guidelines in July 2022 which allowed and set out the boundaries to which restaurants can levy or not levy service charge. So like we can see that in that moment of if any of us go to a restaurant, we are more concerned about spending time with the people that we've gone to. So if the restaurant even levies a service charge and they force us or impose that we are required to pay it, we pay it without knowing that we're not mandated to. The second aspect, like I mentioned, is the strictness of the law. I acknowledge that there is no legislation that bans or restricts the levying of service charge, but there are guidelines, like I just said, that have been introduced that restaurants are required to follow. So even though there are guidelines and not a legislation, which is why the restaurants have had the opportunity to actually oppose the guidelines and say that the service charge needs to be levied on consumers, because the hospitality sector is one that is a service that is not actually very equally remunerated as compared to other industries. My third aspect was the restaurant's procedural transparency. This was one of those questions where I mentioned that if you went to a restaurant or a hotel and there was a board that said that service charges are applicable in this hotel, does the consumer feel that they are mandated to pay it or not? because the defense that the restaurants and hotels have been using for the longest time is that we have mentioned it beforehand in the menus or in the premises of the hotel. So if the consumer can read the items in the menu, they can as well read that they are required to pay the service charge as a mandate. So in one of those major landmark judgments of Mrs. Ahuja versus Pizza Express, like I just said, that the restaurants took the stand that the consumers are required to pay the service charge, as they were already mentioned that they are imposed to pay it. So I would like to conclude by saying that we all know that laws for protection or for providing assistance to us exist, but we don't use them. We lack the awareness, we lack the ability to actually do something about it. So I opine that a service charge is not mandated. A service tax is, which is what we pay to the government. A service charge is what we pay out of out of our own satisfaction that we gain from the restaurant or hotel that we go to, depending on how the server or the waiter has treated us. So I opine that we should be more aware of what laws exist and how the provisions of this law assist us as consumers. Thank you.
Welcome to everyone here, and my topic for today is consumer protection on energy and environment. So basically, what is a consumer protection? It is the policies that aim to protect the interest of a consumer. So now when I talk about energy and environment, it is going to be in terms in the sector of energy and environment. So this in a long run is going to provide a very clean and healthy environment. The important aspect is that in consumer protection of energy and environment, there are sales, distributions and production of energy efficient goods, and it helps in protecting the consumers from hazardous substance and pollution. I'd like to refer a case, USA versus Chevron USA Incorporation. Here, the Chevron USA Incorporation was challenged for violating the Clean Air Act by illegally releasing pollutants into the atmosphere. See, here the Chevron was fined to install pollution control equipments. And there are few legal frameworks which have been implemented. The Federal Trade Commission Act, the Energy Policy and Conservation Act, the Clean Air Act and the Clean Water Act for the clean environment. And the main problem I thought for this topic would be the deceptive ads the consumers face. For example, the misleading advertisements, the transparency of pricing, and the main challenge is greenwashing. So greenwashing is the organization who aim in spending more time and money in marketing the product rather than seeing the environment impact of the product. And the challenges they face are that the energy resources have very high upfront cost, and energy efficient appliances and renewable energy systems are mostly very expensive to be installed. So for example, you can see charging stations. All these electric vehicles to be charged are not found everywhere. It's very expensive for people to afford it. And significant change for these sustainable behavior are to be done in a daily routine. For example, carpooling. So this will help you to reduce the CO2 emissions in the environment. And opportunities, there are economic benefits, there are environment benefits. So by environment benefits, you can improve the air quality, you can reduce the greenhouse gas emissions, and by economic benefits, you can create job entry in the field of renewable resources and decrease the energy cost. And then it's the role of technology. So in role of technology, there's this case, National Association of Manufacturers versus Department of Energy. Here, this Department of Energy was challenged because of lack of legal authority of efficient energy light bulbs. And there's this new technology of smart home technology, where these households, they can control their appliances through their smartphones. Like for example, there are a technology of thermostats where people can adjust it according to their temperature preferences. And there's this case called Calfin Corporation versus Federal Energy Regulatory Commission. So this issued the Smart Grid Consumer Data Privacy Notice and Consent. So this consent was to be obtained from the consumer before they share or before they collect the energy consumption of the consumer.
So by this they prioritize the privacy of the consumer, of how much energy they've used and to whom the information is going to be shared. And the government policies and regulations. And the government has put forth many regulations to protect the consumers. They have got an incentive financially supported for the people so that they can afford renewable resources like solar energy, wind energy. And in the case of Chevron USA versus Natural Resource Defense Council, a doctrine of Chevron defense was brought in so that the government agencies can interpret and implement laws. Then consumer awareness. Consumer awareness has to be brought by campaigns so that people are aware about the misleading advertisement. Now currently in Consumer Protection Act of 2019, there will be a fine of rupees 1 lakh which will be imposed to the people who do misleading of advertisements. And as a basic awareness of the consumers, they have to be aware, like when they leave a room, they see that they turn off the lights, reduce water consumption, take care of their electricity bills. And some of the initiative and suggestions. So the government have taken the initiative of energy labeling. So there's this case called Huang versus Toto, and this was a case because there was no accurate information regarding the water consumption in the toilet, and there has to be. And the government has also bought programs for vulnerable people so that they have access to safe and affordable energy. And some of the suggestion is that usage of eco-friendly products, installation of solar panels by all the stakeholders, and consumers have to see to that they decrease their energy consumptions. And I would like to conclude my project telling, as people get to know, as people know that the usage of energy is increasing nowadays, it is becoming a very serious issue, and consumers have to have the responsibility to use the energy wisely and ensure that they develop a sustainable environment for their future generations. For this, only when the government, stakeholders, and we people join together, we can make the environment a healthy and a cleaner one. Thank you.
To one and all present here, I'm Shravika Pavan from BBA LLB Section B, and I'm a first year law student, and today I'll be presenting about the ambit of healthcare sector under Consumer Protection Act 2019. As the world is going through enormous changes with a wide range of goods and services being introduced to satisfy the changing needs of customers, it has become important, and it is also, in order to provide relief, it became important to safeguard the interests of people, defend them against exploitation, and also offer them with redressal. Keeping this in mind, Consumer Protection Bill 1986 was introduced, and also this was enacted in the year 1986 with the main purpose of giving greater protection of the interests of consumers. This was later again amended in the year 2019, which spoke about giving space for e-commerce, product liability, and establishing central authority. Now, talking about my research problem, I wanted to cover how nature of medical services can be covered under the Consumer Protection Act 2019, that is, can doctors be sued for any deficiency? Now, talking about my sample size, I took a survey of 20 people in order to check their basic awareness about Consumer Protection Act and asking their opinion if doctors can be sued. And the limitation and scope of my research paper is that it is only limited to 20 people, and it is only limited to a certain age group, that is 18 to 45. And this didn't cover any in-depth questions, it was only basic understanding regarding the medical service under CPA and their awareness about Consumer Protection Act. Now, talking about the main content, the ambit of healthcare under Consumer Protection Act 2019. I'll be dividing this into three topics: service, deficiency, and how these two can be put together under medical service. Service, as you all know, is defined under Section 2, Clause 42, which focuses on anything that is made accessible for usage in exchange for compensation. This also includes various services such as financing, banking, financing, etc. But it does not include anything which is free of cost or any personal service. Now, talking about deficiency, which is defined under Section 2, Clause 11, it is nothing but any fault, imperfection, or any shortcoming in the nature, quality, or performance of the goods or services, and also includes any negligence, commission, or omission that leads to any
injury or damage. This basically focuses about the implied nature of the doctors under Consumer Protection Act. Now we all know that failure to provide any inadequate services may cause minor or major consequences, which also includes like any damage, or in extreme cases it might lead to death. So by offering relief in the form of compensation, in accordance with the Consumer Protection Act, the Consumer Protection Redressal Committee gives recourse against any damage for goods or any service aware. Now talking about the main content of this research, the medical profession has a responsibility to take care and precautions while treating a patient. That is, every doctor must extend his duty for professional service in order to safeguard the rights and lives of the patients. In 1995, Supreme Court, the Honorable Supreme Court held that in the case of Indian Medical Association versus V.T. Shanta, saying medical field also falls under the ambit of service and defined under service of the Consumer Protection Act 1986. Also, it also classified the relationship between a doctor as well as a patient as contractual, and they owe each other their duty of care. And in the recent years, a PIL was filed by Advocate Siddharth Luthra for it, and also in that also it was held that medical care falls under the ambit of service. And now the problem here it arises is that there is no expression which is clearly mentioned of deficiency of medical service in the CPA. I also took a survey, as mentioned earlier, with 20 people, asking them basic questions again regarding their awareness about Consumer Protection Act. Now talking about my findings, as we all know that Consumer Protection Act was enacted to address the concerns of consumers for purchasing any goods or availing any services. The main problem here is that medical deficiency of service is not expressly mentioned, as I mentioned earlier, and there are no proper set of rules or guidelines that are mentioned which the Indian judiciary must deal with. And if there are clear-cut goals and rules which are mentioned, it would be easy for the Consumer Protection Commission to actually dispose the case very quickly. My survey findings is that the majority of the people were not totally aware about Consumer Protection Act, either their rights or it's their basic awareness. Talking about the second question, most of the respondents felt that the medical care should also be included in the Consumer Protection Act in an expressed way, and majority of the respondents were not sure if a doctor can be sued because there is no proper legislation on it. Only medical negligence is included. I conclude this presentation by saying that CPA, Consumer Protection Act 2019, is trying to cover all aspects of goods and services, but giving proper expression towards the medical care would help in disposal of case quickly, because the main objective of Consumer Protection Act is to dispose the cases and in an easy and a simple way. Thank you everybody. Have a nice day.
Call back for the fourth session of the day. I once again welcome all our venerated guests, university officers, faculty members, and the young minds present here today. A great man is different from eminent one. In that way, the great man will be ready to serve the society and not the eminent one. And we have among us one such great man and an epitome in serving society, Shri Y.G. Muralidharan Sir, author, founder, trustee at Consumer Rights Education and Awareness Trust, that is CRET. Sir had joined the accounts department of Bharat Heavy Electricals Limited immediately after he graduated. But after 20 years, Sir opted for voluntary retirement in 2001 with 17 years of service left to go, as Sir wanted to devote more time for civic activism and consumer issues. By that time, state government had just established the Karnataka Electricity Regulatory Commission, while Sir was actively writing about electricity issues. The then KERC chairman, Mr. Pilipuz Matai, asked Muralidharan Sir to join the commission as a consumer advocate in September 2001 in the KERC's Office of Consumer Advocacy. Serving in that capacity up to October 2012, Muralidharan Sir managed to form a state-level network of civil society and consumers to work exclusively on electricity issues, facilitated the formation of electricity consumer network, and brought down consumer deposit from 3 months average consumption to 2 months. Sir is a vivid writer who has to his credit writing more than 25 books on consumer protection, RTA and self-development. Sir is a managing trustee of the grid for more than 29 years. Sir, your experience is our age. Sir, it's over to you.
Greetings to the panel and the audience. So, I am Kashish Darak here to present my paper, which is titled as Understanding of Health Sector under the Consumer Protection Act. So, as we have just witnessed that many of the fellow presenters have already touched on the topic, but still here stays something that is still untouched. So, modern era is designated to be the era of consumers. Health sector is also addressed under this act. Here, the patients are seen as consumers. The contemporary issue here arises when health sector merges with e-commerce. Right now in today's era we get everything on e-commerce. We get food, we get furnitures and whatnot. But it has not limited itself just to the materialistic products. There are also various online platforms which provides for medications like Practo, Healthians and such platforms. The doctors here, they associate themselves with the platforms and through this, the consultancy or any other medication is provided. Now the question arises that if there is a deficiency of service from the doctor who is performing on the online platform, who is to be made liable? If the same question arises to a person who is availing a food delivery from a platform of Swiggy, so here the concept of vicarious liability could be available, where the liability could be imposed seeing the nature of the facts as it is several or joint, etc. But the judiciary of the land by far has not addressed any kind of case or has not come through any kind of case which addresses that states that there is a deficiency of healthcare from the online platform. So there are two types of services. That Consumer Protection Act talks about. One is contract of service that talks about master and servant relationship, and the other one is contract for service under which the healthcare sector comes. So there are various case laws that the judiciary has witnessed which talks about various other guidelines, and as I said, this topic is still untouched by the judiciary of the land. The guidelines for reasonable standard of care were led in the case of Dr. Lakshman Balakrishna Joshi versus Trimbak Bapu Godbole, and there are various other cases that talks about medical negligence and etc. So now here there can be two extremes of people arguing about this topic. One extreme can say that the platform should be made liable as they are the people who qualify the doctors to perform on that platform. The other extremes may argue that the liability of the doctor, that it should be liability of the doctor as the doctor is the one who has the prime duty to provide proper care and see towards the well-being of the customer or the patient. The arguments might also arise with regards to joint and several liability. Consumer Protection Acts comes in effect with regards to health sector, mostly in the cases of medical negligence, which needs that three elements has to be present there. It works on the principle of res ipsa loquitur, which means that the mere occurrence of some type of accident is sufficient enough to imply the case of medical negligence. So the conclusion of the paper that I found by far was that, as I said, that the judiciary of the land has not witnessed anything such, but the world evolves and the technology does, and so has to the law. There are various questions that are unanswered yet, that people have difference in opinion, then the question of unforeseen damage, known complication and many more. Here where the judiciary has to make the justice with respect to the consumer, that is the patient here, and integrity of the individual in this profession. Thank you.
Good afternoon to everyone. My name is Dhanashree and I am a first year law student of BBA LLB course. And as you can see, my research topic is price discrimination and consumer protection and analysis of the pink tax in India. Pink tax. Pink tax is basically just extra money, extra expenses for women. It's paying extra for just being a woman. Pink tax is unjust and it's a type of price discrimination that has been prevalent in various markets around the world. There are two possible reasons for this. One is pink tax manifests two ways. that is producers use profit maximizing strategies. It basically means that the producers observe the psychology and observe the customers and charge higher prices for women for nearly identical products, or just because if the product is in a different color like pink. And there's another way for this that involves direct tax by raising the value added of the sale taxes for products that are specifically produced to women. This is an example of tampon tax. Tampon tax is an actual value added tax when in India when GST was increased 12% for tampon tax, that was the first time in India pink tax was observed and awareness was created. This resulted in a huge revolt, and later on India removed the extra 12% GST tax for tampon tax. My objective is to analyze the pink tax in India and then see the legislative actions to eliminate the price discrimination under Consumer Act. Although there is no actual law under Consumer Protection Act that's talking about specifically pink tax, but under unfair trade practices of Section 247 Clause E, it does involve that under price discrimination based on gender for nearly same products, identical products, can be compensated under the consumer products. And pink tax is a silent surgeon on womanhood that we should not have to pay despite the growing awareness of pink tax. The studies in USA have shown that they nearly 42% of the time women are charged more times compared to 18% of the men's product. So pink tax is not only limited in India, it's also all over the world. But few countries like USA, in states like California and all, they opened up a law called the pink tax ripper. This law prohibits corporate and organizations to charge women higher prices than the actual prices for their products. Research questions. Why does pink tax exist in India? Although the awareness of pink tax has been growing in India in the last few decades, there are still few defense for the corporations to defend themselves. That is, basically they tell about how product differences. When it comes to product differences, it's understandable that maybe there's a material or a different kind of material or a higher quality. Due to this, the product is expensive. That can be understood. But there are examples of major brands like Levi, which sells jeans 25% more expensive than male jeans, although there is no difference in the product. And some people say pink tax is because of the color pink. But there are products in like Nike and all, they sell the same black hoodies with the same zipper and the same tags, but I found that there are like almost 1,000 rupees extra charges in women products. My hypothesis is that pink tax is however well intentioned in the corporation. It exploits female consumers and is a form of sexism practiced by organization due to gender stereotypes. When it comes to gender stereotypes, often the corporate believe that women are less price elastic when it comes to like fashion, because they believe that women will tend to pay more for the same product they're selling for male. My research, I conducted a research just to spread awareness about the public on pink tax. This scope and limit is I conducted with Alliance University students, and even among students, only 43% of the people knew what pink tax was. And when it comes to like going to the court for price discrimination, often I actually didn't find any landmark cases that was famous enough under pink tax, because there's a lack of research on this concept in a lot of platforms. And yeah, that's a call. My conclusion is that pink tax is a widespread phenomenon in various products and sectors and services. Even among children products, this is the shockingest thing. Even among children toys, the same toys that are sold to the male and the female children toys are expensive than males because the color of the toy is pink. And corporates have slowly started acknowledging discriminatory of the pink tax, and they slowly taken steps to eliminate and educate consumers about it. Although there are no direct laws or acts under the Consumer Protection Act of India to address pink tax, one can still fight against it with the help of unfair trade practice. Like I said, it's a form of gender-based price discrimination. Eliminating pink tax can be a significant step towards achieving gender equality. It is essential for companies to adopt and transparent pricing policies and take accountability for the actions in this regard. Thank you.
So basically it allows, it says that within a 1 month the Consumer Redressal Commission should work on it. But on average in India it takes 2 years to solve the consumer issue. United States, sir. So basically it is between 3 to 4 hearings, which is less than a month.
Now you said that.
Yes, sir.
Sorry. In the US there is one law so that it takes care of all consumer issues.
No sir, in India we have one law, in US we have separate laws.
In India, do you know how many laws are there to protect consumers?
Sir, it is more than 12, sir.
Then what is the necessity of going to one way or the
That is
For
a-
example, if you have a problem with banking, you have an ombudsman law. If you have an insurance problem, you have an insurance ombudsman scheme. If you have a problem with property or real estate, you have RERA, real estate regulator. If you have an electricity problem, you have electricity regulatory authorities. So where do you think that Indian consumer system, the justice system, is inferior to US?
Sir, as you mentioned that we have separate laws for, these are the nexus, these are the laws that have nexus to Consumer Protection Act, which is more or less connected. But problem is that we brought Consumer Protection Act, and if you take insurance cases, it can be filed under Consumer Protection Act. Banking cases, it can be filed under Consumer Protection. Electricity can be filed under Consumer Protection Act. The reason we did is that if we have separate laws, but the problem was that implementation, people don't avail it. So that is.
Forget about awareness and forget about availability and all those things. Structurally, I am telling, in what way US law is superior to Indian consumer law? Except that you are telling that they have plenty of laws, they have only one law. Actually, if you read the Consumer Protection Act, this is in addition to other laws. So it doesn't mean that people should always go to consumer court or commission. Is it not? So then,
Even relief given in consumer protection is in addition to what relief you will get in the
Yes, sir. But even generally speaking, that if you want to file a case, if there is an issue of both criminal and civil matters, people go for criminal matters because it can be solved easily. So if you go for the civil, as you mentioned, the separate acts we have, if you go under civil court, it will take a longer period of time to solve it.
Please don't confuse, don't jump. I am just asking. I have an insurance problem. I have a banking problem. He has a real estate problem. She has a medical negligence problem. We all go to consumer forum if necessary, or commission. We don't want she goes to something different, he goes to something whichever he feels convenient. Is this not flexibility is an advantage over the US system?
So the flexibility is that the consumer authorities that they are facing. If you have problem, you should have, if you went separately on as per the RERA Act, if you have problem related to real estate and if you go under RERA Act, you will be going in different codes. But when it comes to authority, if you all three come at the same time to me as authority to implement, and I am the only one person, and if this is a case that majority people, and I cannot give you that.
A big round of applause to all the participants over here. It doesn't matter what you guys said, the prize is the one thing which matters here. Moving on to the next session. Water is enough right to burn in the fire or fade into the sky. It doesn't hesitate to shatter against sharp objects during the rainfall or drown in the dark shroud of the earth. Its the versatility exists beyond all end and its beginning. Like said prior, we have among us a man of versatility, Professor and Dr. Ashok R. Patil, Professor and Chair of Consumer Law and Practice under Ministry of Consumer Affairs, Government of India, NLSIU, Bangalore. Sir is a vivid writer. Sir has published more than 8 articles in international and 42 articles in national journals. Sir has to his credit publications of more than 6 books. Sir had visited more than 15 countries and presented various research papers. He had presented more than 30 at the international level, around 60 at the national level conferences and seminars. Sir has to his credit organizations of more than 41 training programs, workshops for non-governmental organizations, consumer forum members, governments and private lawyers, consumer club teachers and others. Sir has received Asian Law Institute Fellowship in 2010 and visited the prestigious National University of Singapore for research in consumer protection issues. As a faculty coordinator to the Legal Services Clinic, Sir received International Mac Genet Award in 2014 at Cape Town, South Africa. Currently, Sir is a member of various international and national organizations, which include him being board member of the International Association of Consumer Law, member of Consumer International London, UK, lifetime member of International Academy of Financial Consumers, Seoul, and so on. Sir is an empaneled mediator for the Indian Institute of Arbitration and Mediation. Sir is also a member of various governmental bodies, which include member of Interministerial Monitoring Committee on issue of Misleading Advertisement and Review Committee on Consumer Protection Amendment Bill 2015. He is also a member of Drafting Committee on Consumer Protection Bill of 2015, 2018 and 2019. Sir is a member of a working group on consumer advocacy of Ministry of Corporate Consumer Affairs at Government of India, New Delhi. Sir is a member to the Central Consumer Protection Council by the Ministry of Consumer Affairs, Government of India since 2015. It's my esteemed privilege to call upon Professor Dr. Ashok R. Patil to address the gathering.
So, good afternoon everybody. I hope everybody is feeling well and good. But sorry for this surprise, but I'm a little nervous. Okay, alright, we'll start. Okay, so my topic is comparative study of Indian and US consumer laws. So in India we have consumer laws, and in United States we have consumer laws to protect their consumers. But the reason why I took United States of America is that if you comparatively see, there are mainly 3 countries that are outperforming every other country in protecting their consumers. One is United States of America, obviously, then Britain, then Australia. But if you take Australia and Britain, they are more or less similar to our Indian laws. And one thing that is a little different from our laws are basically United States laws. So even if you take Consumer Protection Act of 2019, they have taken United States laws as an inspiration to draw our laws. But at the end of the day, it is just a paper until and unless people agree with it. Alright, my research objectives is to examine the current consumer laws in India, to study the methods of effective implementation of USA consumer laws, to suggest the measures of development consumer laws and implementation in India, to access the current consumer laws in India, understanding the effectiveness consumer laws in India, and draw a comparison between Indian and US consumer laws. These are my research objectives, and moving on to the question. Okay. So these are the research questions. Whether Indian Consumer Protection Act can fulfill its objectives or not, what are the scopes and extents of protection regarding the consumers in USA, and can the lacunas in Indian consumer laws of Act 2019 fix the mechanism from the US laws? So basically I am trying to analyze 2 consumer laws, which is Indian consumer laws and United States consumer laws, and I'm trying to bring it what are the things that India can improve to save its consumers from any point of exploitation. So legal frameworks in India and USA. If you take United States of America, there is no one consumer law that says the Consumer Protection Act of United States 2023 or anything. So they have separate and several consumer laws, and they deal accordingly or based on whatever the field they deal with it. So for example, for real estate we have RERA Act and all those things. Same like that, even in United States they have their consumer laws, and they deal separately on specialized manner over there. But if you take Indian consumer laws, they have brought almost every sector in the country to under one consumer law. The reason behind they did this is that in United States, if you want anything, it is easy to get a lawyer and go to a court and go for a consumer redressal commission. But if you take India, even today 2019 Act provides that even without lawyers you can go, as our chief guest has said, that just take a piece of paper and go to the consumer forum that this is the problem with me, and Indian consumer forums are designed in such a way to solve that issue. Because if you provide separate laws for it in our country, people won't be interested in going to the court at all. Already they are not. And along with that, scope examining the Consumer Protection Act and its implementation in India. In India, we are very well good in planning. That is something that we all are clear with. But one thing that we lack is implementation. Majorly, there are 3 burdens three challenges that Indian consumer laws faces in India. One is overburden of enforcing body, lack of sufficient stocks, and backlog of cases. So one is overburden of enforcing body. CCPA, which is Central Consumer Protection Authority, is the enforcing body of our Indian consumer laws, and they enforce the Indian consumer laws in our country to protect our citizens and consumers. But the problem is, as I said, they have brought all the sectors in one law, which has one enforcing authority, which has few commissions to advise them and district forums. But I don't think, or the studies have proven that they are not that efficient, because they have to deal with any type of cases that happens in any sector under one law. That is completely, it is hard to, it is one of the biggest challenges that we should overcome. Even if you make it separately and specialized manner also, it is hard for the consumers to come up to the consumer forum. If you bring everything under one consumer forum, then it is hard for the consumer forum authorities to deal with the issues. So that is one of the issues that we face, and lack of sufficient staffs. Supreme Court has to come and tell the consumer ministry and consumer authority to appoint the presidents of member of states and district consumer redressal commissions. So to appointment of the presidents and the members for the consumer and district redressal commission, the Supreme Court has to come. Then what are the things that we have to improve? Because a lot of things has not yet to be done. And along with that, in Bangalore, Consumer Redressal Commission performs at 85% of workforce. But the investigators who are in this consumer forums conclude that it is not enough, man. And along with that, backlog of cases. UP is the number one state which has 25,000 cases, 25,500 cases. And Karnataka is in the third position with 10,433 pending cases in India. And in India, 225 cases are filed every month on average on the consumer forums. So we do not have enough workforce, enough resource to manage all these cases at the same time. And moving on, in the past 10 years, the pendency of cases have gone fivefold. And that I'll give you a case study where a man has bought a telephone for 2,000 rupees. And he went to the consumer forum after it stopped serving its purpose after a month. But consumer forum took 2 years to give 2,000 rupees compensation. If that is the case, for 2,000 rupees you have to wait 2 years, then how many of you will go to the consumer forums tomorrow? The law students? Alright. Then moving on, there was in India we have one thing lacking is that we don't study the implementation of consumer laws in India. Even the Justice K.L. Kaul and Hirish Roy have said that we must improve our matters in studying the just the consumer laws, and we have to give a deep study of what are the things that we have to improve on it. Even they have mentioned it. Along with that, if you take United States consumer laws, we have a long way to go, man. Because United States is a country with enough competitors and the companies. Even any strict action in India will affect the foreign direct investment or any kind of new entrepreneurs coming up. So if you take strict action against the business, it won't satisfy the business people to come up and it won't encourage them. But if you leave it like that, it will also affect the consumers. At the end of the day, a law is just a paper unless and until we practice it. Thank you.
So much all the presenters. To a big surprise, we have a surprise presentation from one man who was very interested to give his paper presentation. So cheer it up for Sri Ram.
Greetings to the audience and the dignitaries present here. I'm Vaishnavi and I'm here to present my paper titled Understanding the Shift of Burden to Caveat Vendita in the Context of Consumer Protection Act. Through the earlier presentations, we now have a brief idea that it is mostly the responsibility of the seller to be aware of the goods and services they are offering for sale. Before understanding the concept of caveat vendita, I'll be discussing about the initial or past rule that prevailed, that was caveat emptor, which means let the buyer beware. It was one of the rigid rules in India and around the world that placed the entire burden on the shoulders of consumers regarding the obtainment of goods and services. Later, this rigidity was observed where along with the burden, it was seen that the consumer didn't have any recourse to obtain against the sellers for the defective products and services they obtain and the harm they suffer. Thus, some exceptions were introduced in this rule, and later, several evolving and dynamic situations called for the necessity of establishment of rule of caveat vendita through the introduction of the Consumer Protection Act. Caveat vendita is contrary to the rule of caveat emptor, which means the seller beware. This brought a new sensation in the market system, trade and commerce. Caveat emptor, which was based entirely on the skillful judgment and due diligence of the consumers, gave an undue advantage to the sellers to adopt market manipulation techniques and unfair trade practices. Hence, it became mostly detrimental to the consumers. As time went by, it also became difficult for an ordinary man to ascertain the nature and description of the goods because of the changing and improvements in the developments of products and services offered in the new era. Hence, it called for the establishment of caveat emptor because of these notable changes, and it happened that shift of burden was given to caveat emptor from the caveat emptor. The transactions has evolved from traditional to digital that involves electronic means in this new era. But the progress sadly has also exposed the consumers to more exploitation, and to protect the consumers from that, new reforms has been introduced through the Consumer Protection Act of 2019, and the notable one is the Product Liability Action, which offers recourse for the consumers against the sellers for the harm they suffer. It has also widened its scope through this amendment. It holds the sellers responsible for restrictive and unfair trade practices, misleading advertisement, defective products and deficiency services, and the harm they suffer, and unfair contracts. Consumer Disputes Redressal Commission are established at every level, that is district, state and national, to hear the grievances of the consumers. The fair usage of this rule is expected, and complete ignorance, misapplication or unreasonable act on the end of the consumers are not entertained. For the first time in Ashington Piggeries Limited and another versus Christopher Hill's case, Lord Diplock sensed the swing of pendulum in favor of the then new principal caveat emptor and was alarmed about the arising changing situation. To talk about one of the case laws, that is Zamiruddin versus Nidhi Medicos, the seller allured the buyer into buying a capsule, saying that he will be winning a gold coin of 25 grams. However, it was a lottery ticket unknown to the knowledge of the consumer. Hence, the seller was held liable for the unfair trade practices, and the judgment also entitled the buyer to receive compensation from the seller. Caveat emptor was introduced for the fair treatment of buyers, and the consumer must keep in mind the maximum of equity and approach the court or concerned authorities with clean hands. It might be a question that whether caveat emptor is completely replaced. However, according to my findings, it is still relevant in the real estate transactions and also in the nature of transaction between, or the process of transaction or steps of transaction between a buyer and a seller. Also, as an ordinary prudent man, it is also the responsibility of the buyer to tell the purpose and need to the seller, and from there the responsibility of the seller starts, and the shift of burden is shifted to the caveat emptor. So, the supply of goods according to the fitness of the buyer's purpose and the product of a merchantable quality is the responsibility of the seller. By this, I conclude my presentation. Thank you.
Good afternoon, students. So after lunch, you are awake? Yes. Fine. This is the problem with us. Particularly, my fate is like that. Either I will be asked to speak before lunch or after lunch. This is happening every time. So I try to be as brief as possible. Okay, I know recently I am reading a lot about neuroscience, that is psychology. The young people's attention span is not more than 15 minutes, or maybe 10 minutes lesser than that. Right? So, but I will not be that short because I have to clear myself of this. First, my thanks to Dr. B.S. Reddy for having given this opportunity to be with you and see young faces, get ourselves motivated to do more things. One, of course, Kilpar, Mr. Revaya, Dr. Revaya Odier and Sri Divakar Babu, who have been extensively traveling the state in promoting consumer awareness and other illegal issues. You may be surprised. A few years back, maybe some 12 years or 13 years back, Kilpar had organized a program on some awareness like this in Tumkur town. that was the first time when I saw Dr. B.S. Reddy. So he was speaking about corruption, anti-corruption, sorry, put together. So then now, I was then doing research and writing a book on corruption. It has already been published now, both in Kannada and English. So that's how we started and our friendship. Still now it is going on. Thank you for your cooperation, sir. And he has come to invite me to our house twice for this program. It's something great. Nowadays nobody bothers. Just put it on website or put it on WhatsApp or some SMS, you are expected to come. But that's not so. I told him not to come, but still he has come, and thank you very much for the decency or the dignity which we are being taught by the elders. Now coming to the subject, sir. See, I came to this consumer movement in 1993. None of you would have been born, except 2-3 people like us. Is it not? So I want to just put a few things before you, a few lines to, right perspective. Dr. Ashok Patil has spoken to you about the recent advancement in the consumer issues and all, but that is not exactly 100% true. There are certain things which has gone beyond before that. Because what you are seeing today is a big building here. You are enjoying. But you go and ask the person who constructed this one, he will tell you what is the problem you had. So 1984, nobody knew about Consumer Protection Act. I remember 78 or something like that, there was the first international convention on consumer education and protection in Bangalore. 78, 76 or 78. Sorry, I am not in. At that time, we had what is known as Karnataka State Consumer Protection Board, the first institution in India to start such a board for consumer protection. It's an institutional mechanism. India had never thought of consumer protection, but Karnataka had thought of a board to protect the interest of consumers. That is the starting point. Thanks to one great lady, where is Mr. Devaya? He is not there. He will come. So this Jaji Mandanna, a great lady who is from Coorg, because Devaya is from Coorg, that's why I just wanted to ask him. So she contributed a lot, and recently at the age of 92 or 93 she expired in a hospital. Nobody bothered about her services. Only I tried to write a letter to her parents, people in their house and all. So that started the consumer movement. The first draft was prepared in 84. No lawyer, no law teacher, no institution ever gave their responses for the bill, Consumer Protection Bill, 84. It was only done by entire civil society, NGOs, what you call. If I say NGO, you will take it as a second-class citizens. So we say civil society. It's a new word. Is it not? There was one great man called H.D. Shourie. Have you heard about him? No. Have you heard about Arun Shourie? Indian Express former editor, who is known for his investigative journalism, who brought out Bhopal tragedies, that is Bhagalpur tragedies. So his father was H.D. Shourie. He was the first man to draft a bill on consumer protection. At that time he was a 75-year-old man. Okay? And then, of course, we had some institutions like CERC, Ahmedabad, Consumer Education Research Association. Still it is there now, running. Consumer Guidance Society of India, one of the oldest association in the world, 1972 it was established. And take it from you, it was established by 12 women, not more than like your speakers here today. It is still working. A civil society to work this much long without many support, you can imagine. And then we had one, of course, my mentor, who died a year back in Bangalore. It's called Vaishaka Consumer Protection Council in Andhra Pradesh, 1973. So these are all the landmarks which we should tell you people. It's not merely after 2000 bringing something and then asking some parliament people doing nothing. The seeds of consumer protection was laid by the NGOs, by the civil society and not by the parliamentarians or the legal society. This I want to put it straight. Now we may talk so much about these things. We may criticize the Consumer Protection Act. That doesn't bother. But those days were there. And thanks to Rajiv Gandhi, who was the Prime Minister, who brought the Consumer Protection Act into a legislation. Okay? So we all forget about all this history because we have to learn from history, is it not? And highest compensation in the draft of the Right to Consumer Protection Act was 10 rupees. So Rajiv Gandhi said, what nonsense is this? Our bureaucrats are like that. So he threw the bill and said you will redraft it. That's how issues came up. So that's how consumer protection. So 93 I was involved in this consumer movement because then the act was there, 86 act was there. So around 8 years had been passed, 7 years. There was not a single consumer association in Bangalore to promote consumer awareness. Understand? In Bangalore, not a single association. One or two ladies, one lady was doing that, Jajimani, I said, she was quite old and she left it. Another legal person, she was doing, except that there was no institutional mechanism. So that's why I went around the Karnataka state, I went to Tamil Nadu, I went to Ahmedabad, I went to Delhi, and contacted all these people and tried to set up what is known as CREATE, that Consumer Rights Education Awareness Trust. That is the name was given by somebody, very nice name. So one of the president of the state commission came and told me, Mr. Muralidharan, this was in 20 years ago, after 20 years, you will be have to change your C to G because it would have become great by then. So that's how our institution started. And we started with 500 rupees, 1994. Our balance, bank balance, even today if you see the balance sheet, it is only 500 rupees. But we moved on to so many areas afterwards, and at one point of time, it creates the balance sheet. Our turnover showed 25 lakhs per year. So for an NGO, it is a great achievement. Why I am telling you this one is, somehow the modern trend is to brush away the contribution of civil society for consumer movement. That should stop. If there was no civil society, there would have not been any law on consumer protection. For that matter, RTI, right to information, without women, without a person like Aruna Rai, there would have been no RTI. Is it not? So without these people, consumer protection would not have come. So take it from me. Second is, we need to look into now, theoretical aspect has been spoken by Dr. Ashok Patil. Afterward, all these chairs and other things started in almost all colleges and universities. Now they are doing. But unfortunately, what I feel is, either in this college or any college, I am not blaming any one college, throughout the society I am telling, a movement which are supposed to be grassroots level, at the poor people's level, is slowly being hijacked to the rich people. Slowly. No, nobody bothers about the poor man. That's why when we were having our lunch, I was talking to that lady, I don't know her name. Sukha. She was telling, I told her, see, many people were unable to tell answers for some questions. But I ran 100 consumer clubs in Bangalore city, government schools, 100 consumer schools identified running consumer clubs for 8 years, I think so, 2 slabs, 4 years. There was one government high school I went to, Hanumantanagar in Bangalore city. Some 40 students were there. You know government school students, how are they? They don't have chappals, they don't have books properly, they don't wash that properly. So many problems are there. Don't think that society is like this. I asked that boys and girls there, what are the problems that you are facing? At least 30 people stood and said, Sir, we are not getting rice and wheat properly from our PDS shop. That is real consumer movement. The fake review in Amazon or Flipkart, ordering your items, they are all only for 2% of the people. What is real problem is availability, or rather non-availability of the basic necessities of the people. That is consumer. So I find great opportunity with you people to work towards them. Instead of taking up larger issues, please take up those issues. In fact, we started like that. Okay? Now, this is what I want to like. The second thing is now, I have been asked to summarize what you people spoke, these 12 people. I thought it is 11 as a cricket team, but one more was added afterwards. But, so it is 12 now. So, all the 11 people, or the 12 students have done excellently well. Take it from me, I am telling from my heart. Given your background, given your first year experience in this college, few students have given out of the box thinking. I should not mention the exact one because that will color the judgments people here. I am just giving generally. So, for example, you have, for 1 minute, I have noted down some of the issues. It comes under Consumer Protection Act or not. Product liability, medical service, online put together I am telling. Awareness about CPA, so two students have done it. Energy and environment, working of consumer commissions, that ladies, girls, she said councils, it is wrong. It's not council, it should be commission. Then of course now I have to tell pink tax, that is out of box thinking. Then comparative analysis of India and USA laws. And then the service charges. I think I am not in the same order, I am just giving you here and there. So these are some of the major issues that you people have done. It's wonderful exercise. This shows that you people have read something. So let me thank all the 12 people, and of course, this is a society where all are equal or some are more equal. So 3 people will be more equal, and the 9 will be almost equal. So those 3 people will be given to you shortly. That I don't want to go there. Anyway, I have given my job, it has been done. But don't stop here. Don't do this mistake. It is like Vipassana meditation. You have seen anybody has gone to Vipassana meditation? Out of 12 hours, 10 hours you should be meditating. So there was one comedian, what is it, stand-up comedian telling. So he went, it seems. So 4:30 morning the meditation started. So he suddenly woke up, I thought it should be 6:30. It was only 4:32, only 2 minutes. So meditation happens like that. We feel that it is long, but sleep is not like that. You want to sleep 5 minutes, it will be already 1 hour over. So that's the meditation time. So don't stop here. Try to continue your reading. Try to continue your knowledge. Believe, dear students, we never had this sort of facilities. No, completely no, this facility. Like this hall I have never seen in my 5 years of college life. There was only, I studied in what is called as MES college in Malleshwaram, one of the prestigious college. Not that I read it, it was told like that. Throughout the building there was only one door. You can never go out without the people like him standing there. We used to call it as Jallianwala Bagh. Even if you shoot, you have to go there only. Okay. 5 years, I don't remember to have spoken to one girl. It was not allowed. If I speak to a girl or even see her, oh, what is that you are romantically talking there? So we lost that opportunity also. Okay? So, you people are lucky. You are having anything can happen here. Unfortunately, my parents were in a hurry. I think they brought me quick here. So we feel that we have to be with you. So that's. But please use the resources available with you. Your parents are spending lakhs of rupees. Mind it. But apart from that, that society is spending a lot of money to you. You have to give back to the society something, is it not? It is not mainly your money or parents' money. When the society is spending some money for you, you have to give back. How to give back? You have to identify. It may be through consumer protection, it may be health, it may be whatever it is. Legal service, whatever you want, that is to be chosen. So this is what is called. Second is, I found that your body language of all these 12 people are excellent. They speak very well, their body language is good, they don't have this stage fear. We all suffered that stage fear earlier days. Now nobody bothers, they talk in whatever they want. So that's how it happens. Nice it is. It is nice to know that young girls and boys speaking very well. I remember one small anecdote. There is a boy like you. He was born with a small defect of stammering. He could not speak. But he wanted to become a legal, that is advocate, lawyer. So his parents and relatives said, see, you have this defect. Unless you overcome this defect, you will not be able to raise your voice in the bar. Bar means not that bar, I am telling about this. In the law courts. What this boy did, by that time he had come to college. Like Winston Churchill, he used to stand in front of a mirror in his house and talk to himself. So he improved. Without any medicine of those days, nothing, no much of medicine and all those, he improved. So days passed on, I will cut short the story. So one day, he wanted to speak on Indian budget, finance budget. So the local chamber of commerce in Mumbai, those days Bombay, they called him to speak on budget. Hardly 25 people were there. Next year, they had to hire a bigger hall like this, some 300 people there. Over the years, what happened? They had to hire Wankhede Stadium, cricket stadium, because that much of crowds used to see or to hear this gentleman called Nani Falkiwala. A boy with stammering. Can you imagine for a budget speech having lakhs of people? Keshavananda Bharati case was going on. Falkiwala started arguing from 10:30. It was almost 5 o'clock in the evening. Single man. You read it. Then he said, Your Honor, I would like to stop now. Then the judges said, we want to hear you, kindly go ahead tomorrow morning also. That should be your idea. I know everybody cannot become Falkiwala, everybody cannot become E.S. Venkatramaya or anybody. But that is the spirit what you have to read. Read. Okay? So, your speech, that's what I want to tell. Your speech is very good. No doubt about it. Somewhere you need to improve. Some fine tuning is required. Kindly do that well. Okay? That's what. And of course, we know we can talk of half an hour here or 20 minutes. But you have given only 5 minutes. So time is the main constraint. That you should understand. Within 5 minutes or 8 minutes or whatever is given, whatever time is given to you, you should be able to put in your efforts in a logical order. In few students' case, I did see that logic. Logic in the sense, you are talking something, going somewhere and then coming back, all these things should go. It comes. When you start talking, it will come. It is over a period of time, you can learn that one. So that logic is to be there. And putting so much of information in 5 minutes is a very difficult job. Some of the organizers went to C.V. Raman, the great scientist. Sir, we want to invite you for a talk. C.V. Raman asked, what is the time I can talk? I mean, the time given for me to talk. Why, sir? No. If you ask me to talk with 10 minutes, I require 1 week of preparation. If you want me to talk 5 minutes, I require 15 days of preparation. If you want me to talk whatever I want, today itself I am ready. Can you imagine? This is C.V. Raman speaking. So, putting that much of information into one box or one framework is very difficult. Kindly cultivate that. Brevity is what a lawyer has to understand, is it not? A legal man. You cannot simply go on writing. In fact, I am reading 2-3 articles, I read 2-3 articles now. That puts on me judgment, privacy judgment. Why it should be 578 pages? Have you read it? Any student has read it? Privacy is a fundamental right, puts on me judgment. 578 pages. Why? Forget about that. March 2nd, Supreme Court gives an order. There should be a panel to appoint the election commissioner. 378 pages. One line is enough. 170th report of the National Commission, Law Commission of India has already given it that this should be the case. Committee on the Review of the Constitution of India by Venkatachalaya has given in one paragraph that this should be the follow. That's all is required. You confuse people like hell and a lot and do all those things. So that's why we read only the operative portion and keep quiet. Is it not? So brevity is very, very important. How are you going to improve this quality, this one capacity? You please do it. Of course, the third one is something what is called as knowledge, I think. Of course, I give exemption to first year students because you are not read properly, not much of reading as we are reading, but you have to start reading. I was told by Dr. B.S. Reddy that library is excellent. I want to go and see. The first thing I go anywhere is to see the library, wherever I go. Long back I went to this one, where is that one? Malaysia, to attend one of the consumer conference. So I brought 2 suitcases of something. My wife was telling, oh, she got very pleased. So much of things may be there from Malaysia. That was the first time I went abroad. Both the suitcases were completely filled with books. She did not talk to me for 2 days. So you have to have that urge to read. B.S. Reddy came to my house, you ask him how many books I have in my house. Kindly do that habit. Books has to be with you. Books. That's why for a legal professional, books is called an asset. There is a depreciation for that under the Companies Act or the Income Tax Act. Is it not? Books are your assets. But nobody reads. Now everybody reads only Kindle edition, that edition, this edition and all those things. Books is very much essential. Okay? Right. So the knowledge is very important. I find that somehow, for example, one girl or boy, whoever it is now, energy and environment subject was there. You should have focused on Indian law about environment, about energy. Lots of information is available in the internet or in your religion. And then of course, product liability, so education, whether education comes under CPA or not. So some judgments are there and everything is there. Probably in 1976 or 78, V.R. Krishna Iyer has given one judgment. It's a BWSSB case where he says education is industry. Dear students and the people here, I am not a law student, I have not gone a law degree, I am not a law degree holder, but still I am trying to convince you that I know a little bit of law. Okay? So that is the major judgment. So you have to, the more old judgment you quote, you have value as far as law is concerned. Is it not? The precedence will be there, somewhere there. Okay? So this one, of course, education is comparative analysis. Then itself I raise my question to the boy. It's not so. One of the fundamental rights of the consumers is right to choose. So I should have the right to choose whichever court I want, whichever law I want. It should be more, not only centralized in one. Agreed? That's why we have so many laws in this country. People say, oh, how many laws are there in this country? How many laws are there? Anybody have done any exercise? How many laws? Are there senior students if you are there? We don't know. Even Government of India doesn't know how many laws they have. Government of Karnataka doesn't know how many laws are there. So many laws are there. Now, yesterday I saw that speech by the law minister. In the next session of the parliament, they are trying to remove 68 laws from their books. So far, some 570 laws have been removed. There was a commission to remove the laws. What are the laws to be removed? Vivek Debray, one of the famous economists, who is now the advisor to Prime Minister in Economic Division, he recommended that some 500 laws should go. They have removed it in one bill. So repeal of law is another good subject. Anyway, that you have to look into. So service charges. So this is also a very good subject. So subject wise you are good. So a little bit of talking, little bit of analyzing, and you need not repeat if somebody has done it. You can say my predecessor has or earlier speaker has said, so like that you can carry. So because your time is important. So we need not bother about all that this one. Okay. Now, as our Divakar Babu was telling, first read whatever you want on that subject. Mark certain things in your paper or mobile or whatever it is. Nowadays you people don't prefer paper and pen, you know. So, yes, by the side heading, you should be able to explain that. Agreed? This linkage is very important. Entire lot you can, if you do it here, you lose your marks, you lose your prize. Not, okay? You have to just remember it, and you can remember more better than us, aged people. So this is what I wanted to tell you. Now coming to the subject, 2 legs are over, 3rd leg what I am telling you is, what is this consumer movement about? We are talking about consumer loss. I would like to talk on consumer movement as such on a global level or on a holistic level. One, we are assuming that consumer protection is Consumer Protection Act, which is very, very wrong. Consumer law or any laws for that matter is only a part of the movement that you are looking at. Consumer himself is having some 12 to 13 laws in this country. Is it not? Weights and measures he spoke, Food Adulteration Act. Is it not? So that's only part. Law is only one part, also one segment of the consumer movement. But what is consumer movement? If you look into the history of the consumer movement, you will know how this developed. Some events have led to consumer protection. Event means some event takes place. There was in US, a highway. A gentleman went there and he used to sit for months together on the near the highway. Just sit there, take a book and note down. What he is noting down? Whenever the accident takes place, a car meets with an accident, he will note down the number, he will note down the make, who is the manufacturer. That's all. He is not doing any investigation work. But over a period of 3 months or 4 months, he came to know by his notes that one particular make of a particular company was involved in the highest number of accidents. So what does it show? He came out with a book called Unsafe at Any Speed. The gentleman was Ralph Nader, who is considered the Pitamaha of consumer movement of the world. He is the father of consumer movement. It was produced or published in 1962, Unsafe at Any Speed. So he took on the giant like, what is that one big company, car company, Ford company. He filed a complaint. He was a lawyer by profession. He filed a complaint. He was a lawyer from Princeton College, and he won $1 million in 1962. Entire $1 million was donated to one NGO called his own NGO, and that still is working. He is still there. So Ralph Nader is considered, okay, that is an event, because that is the research that you should do. And on his 60th birthday, he came to India, Ralph Nader. Somebody asked, everybody is calling you the father of consumer movement, what is your view? He said, my dear friends, if at all there is a Pitamaha of consumer movement, it is Mahatma Gandhi, not me. But nobody reads about Gandhi now. Is it not? Even yesterday one book has come on Gandhi. Okay? So he has given. So that is events. There are certain books that has changed the consumer movement. Books about, even another one I can say, Bhopal gas tragedy. Your Environment Protection Act and Public Liability Act came only because of Bhopal tragedy. Is it not? So events give loss to the nation. Similarly, books written. One gentleman went, how many of you have read Robert Ludlum's books? Novels, not books. Robert Ludlum? No. Arthur Haley? Arthur Haley? Ah. You read their novels. You will get to know what is about it. They do research before writing novel, not like James Hadley Chase. Okay? So, that books have created laws, created institutions, created movements. One is another one, what is called as jungle. And then Silent Spring. It is about the effects of pesticides on plants and human beings. So that's how it came. So that's how many laws have been enacted in the US and UK and Indian conditions. That's how some of the events and books are there. Of course, some research studies have done it. Ultimately, what I would say is there are 5 things you should look into as a consumer movement. It is the people, it is power, it is human rights, it is environment, and finally it is justice. These are the 5 pillars of consumer movement. You are looking at only justice. Other things are left. Consumer movement is about people and about power. What power do you have today? Do you have any power in the marketplace? Think over it. Power. To buy anything is not power, I am telling you. To refuse something is power. To say no is power. Is it not? And but power, how many of we people are exercising? That's another one. Ashok Patil was telling what to do when the auto meter goes for defective meter in the day. Every knowledge is available in this world, particularly in this country. Knowledge is not converted into action. That is what consumer movement wants now. You have plenty of information, but action is lacking. How to act? So that is what is called one of the pillars of consumer movement, that is power. So now for example, when you vote in an election, you are voting for a person or a party. Similarly, when you purchase a particular brand of product, you are voting for that brand. If you stop purchasing only, that brand will go out of market. Boycott. The power to boycott is one important aspect of consumer movement. And who started this boycott movement in India first? Mahatma Gandhi started boycotting salt tax and boycotting British goods, broadcast, anything. Now you understand who is the father of consumer movement? Okay, one thing. Then how to, of course, human rights, you are all knowing, you are reading so many laws about that human rights and all. Every right starts with human rights, even consumer rights, it starts with human rights. Labor rights start with human rights. So human rights is fundamental, is it not? So we have to consider consumer rights as human rights, because food, clothing, shelter, roti, kapda, makan, that is important for us. That is human right, is it not? That's also consumer rights. they have found what is known as how to activate now this consumer theme. One is the power of one. We have power. That can be divided into 5 power. One is power of one person can do anything. I already told you how Ralph Nader started doing, how Mahatma Gandhi started doing, how Helen Keller started doing. They are all one person's activities. No group, no nothing else. Is it not? So power of one, of course power of many also. So many people joined the freedom movement, they were able to do something. So power of many is there. Then the power of faith. How many believe here that you can change the society in today's context? Nobody will believe. You believe? Great man.
Only with others.
Others is always there. But first you should have the faith that I can do something. Forget about changing the society. At least you can do something. Don't you have faith in passing the examination? Without faith, are you sitting here? Are you paying some donation and reading in this, learning in this college? No, you have some faith. Somewhere some doubt comes, afterwards let us see that one. Is it not? So faith if you don't have, what can we do? So cultivate that habit of faith. Only then consumer movement can go. That's nothing else. Power of information. Information, what not necessarily you want, but what will people want also. So now Ashok Patel was telling that what are the, where you will go to complain. Now this college, this set of students, I advise or I will request, no, Deva has come now. I was mentioning your name, sir. Anyway. Now, you should form a small group here. Teachers to please make out this as an activity plan. Some 20 students, 30 students, 15 students, whoever it is, you should start a consumers club or study circle or something like that. There is no point in me coming here, taking money and going away like this. You have to do something for it. It should be backed up by this knowledge. That is what Kilpar wants. That's what B.S. Reddy wants. That's what we want. You should develop. Next, somebody in another college wants this sort of seminar or workshop. You should be the resource person. Okay? So, that group can start working on consumer issues. Field study, surveys. Now 15th March, we are having a small study group like that in BMS Law College, Baswangudi. Students are going around that Gandhi Bazaar circle and wherever on 15th March with placards and all those things. We are distributing a small questionnaire asking them, do you know what is consumer rights? Second is, if you have a problem, where are you going to complain? That's all we are asking. Only 2-3 questions. So they are distributing and then taking it. That will become a very big data for you. Based on that data, you can do some other work. In, I think this Anekalala is semi-rural or semi-urban, what you call. Kindly do that work. Do some field work. Doctrinal, everybody will do.
A very good evening, guys. Good evening. Good evening. I didn't hear a voice, guys. It was a very good interactive session. Yes. Good evening. I thank each one of you for being with us here today for the one-day seminar on Consumer Protection Act 2019 organized by Karnataka Institute for Law and Parliamentary Reform, Bengaluru, in collaboration with Alliance School of Law, Alliance University, Bengaluru. I would extend my warm welcome to our esteemed guests and the leadership of Alliance School of Law once again. We all need someone to look up and inspire us to do better than we know how. And we have with us Dr. B.S. Reddy sir, who has greatly committed to the idea of upbringing the young minds. Now, I will request Dr. B.S. Reddy sir, Professor, Alliance School of Law, Alliance University, for the welcome address. Sir, over to you. No? Niharika Jitendra Batra. Sudiksha I. Ritisha. Thank you, sir. Now I request Professor Dr. Ashok R. Patil, sir, to do the needful. Shravika Pavan. Sindhu. Pragalya. Lasya. Thank you, sir. Now I request Shri YG Muralidharan, sir, founder of NGO Create, to distribute the prizes. Kashish. Vaishnavi. Dhanushri. Shriram. Thank you, sir. Now I request Sri K. Dwaraknath Babu, sir, Director, Kilpa Bengaluru, to distribute the prize for our winners. The third prize, there has been a lot of dilemma in choosing it, so it's been shared between two people, Dhanushri B and Lasya CR. And the second prize goes to Sudiksha I. The first prize goes to, any guess? Niharika. The first prize is of 1,000 rupees, second prize is 700, and third prize is 500. Thank you so much, sir. Now I request Professor Sukanya Priyadarshini ma'am for the vote of thanks. Ma'am, over to you.
Thank you, sir. It's a pleasure to thank you after such a wonderful lecture. I see all refreshed faces. Referring to the conversation that me and sir had while we were having lunch, thank you for bringing up the curse of being entitled, something that we've all forgotten. Thank you for bringing up the importance of history, and thank you for making our students realize that the consumer movement is much broader than just the Consumer Protection Act. So I would like everybody to give a big round of applause to sir again. We will now move for a tea break, short tea break, and then in 15 minutes when we reassemble, we can start with the valedictory ceremony.
That's one sort of power of information. The second is power of success. So success is also power, is it not? Power is also success. Success is also power. I am telling power not in the sense of political power. That's also required. There is one small book by Bertrand Russell about power. He talks about social power, he talks about political power, he talks about spiritual power. Now I am really astonished. The highest number of young people going to a godman is young people. Right. So every bookseller is telling, sir, you write something about religion and spirituality. People are buying like hotcakes. So maybe that they are interested, is it not? That what is that one? Guru Gopal Kasar. Have you heard about it? YouTube. I am regular. I watch it. So he was telling, do you want a very lucrative profession? All the students are telling yes, yes. Then go and become a sannyasi with gadda and all those things, because you can millions. Is it not? How much you can do? Even you can surpass Adani if you become a spiritual leader. But don't do it like that. So these are all some of the issues that I want to flag on. Consumer movement, don't restrict to Consumer Protection Act. Please, that is not the intention. As a law student, you can learn, go to the field. One or two subjects I would like to tell you. One is you can take up some field survey on a particular subject, on a particular issue, whichever you want, collect the details, collect the people's information, and then try to move the government for a particular law or an amendment to the law. Unfortunately, in our law syllabus, I have not seen any, I don't know where available in other states or not, I have not seen one subject about pre-legislative scrutiny. Pre-legislative scrutiny. Before a law comes into picture, the draft is put up on the website, at least Central Act. You can go on giving your views on that, whether they take it or not, leave it. Law students should develop that habit of giving their opinion. Don't be bothered about their rejection and all those, that's always there. Kindly do that one. So this sort of practical exercises. Now you have read so much about Consumer Protection Act. What are the loopholes in the Act? Not many people mentioned except one or two students. Any number of loopholes are there, in spite of all the tightening done by the 2019 Act. Is it not? So identify that loopholes. What is the solution? That's also important. Don't go on criticizing. Okay? So criticizing is not, will not give you anything. I'll just tell a story and then come back, stop my. A lady was complaining about the neighbor lady's habit of washing clothes. No, the lady used to wash the clothes and hang on the compound or somewhere, the next day. This lady used to see from here and complain to her husband. See, that lady, she is not washing the clothes properly, she is not hanging it properly, and all those criticisms started. It doesn't look nice at all, blue mark is here, and all those things. This continued for 3-4 days. Then the husband was fed up with this criticism, but till he what to do, he has to hear. So finally one day She said, that wife, my dear husband, today that lady has washed very well. Things are looking beautiful. I think somebody else would have washed it. Something. The husband said, no, 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 no. Today I have washed my house window. That is why it is happening very well. You got it? So first you have to wash our house window to see what is there clearly in there. Thank you very much.
Good evening. Good evening, sir. From morning, we have heard so many resource persons speech, out of which I am very glad and proud of our students, 12 students. We have presented very nicely and we have a better future. In the background of this seminar, one-day seminar, if you look into the historical perspective of this Consumer Protection Act, not only in India, even in America and England, we the Indians are fortunate in enacting this Consumer Protection Act 1986 with the help of the precedents held in common law principles of England, Donaghue v. Stevenson and Rallis v. Fletcher. The Bhopal gas tragedy has been decided keeping in mind this precedent of the common law principles. Later on, we looked into this, the advantages and disadvantages or shortcomings in 1986 Act, and our resource persons have made it very clear. Even in 2019 Act, we have come across with certain defects, and what is the difference between this consumer protection law and consumer movement, that has been made it very clear by our another resource person, Muralidharan. And our director Kilpar, he has given ideas how to move with these the programs and the students how to prepare their papers. In addition to that, Muralidharan has given so many guidelines for the students for their future preparations. With this background, now the last session, valedictory session, it is my pleasure to welcome the dignitaries on the dais and off the dais. I welcome the Kilpar director, Taraknath Babu, to this valedictory function, and despite his busy schedule, he has agreed happily to be the chief guest, and he has supported for this function. I welcome on behalf of Alliance University, on behalf of all the students present here. Welcome. The first resource person, Dr. Ashok Patil, very close friend of mine, and we have participated in many conferences, seminars, and many meetings also. Very dynamic personality. On behalf of Alliance University, I welcome you, sir. Muralidharan, the founder of CREATE NGOs, and he spoke well during his session, and he is now more than 70 years, 65. Though he is 65 years, he is working like a young student. If you go and see his library in house, we may become understood. Now he is working on the project election reforms assigned by Kilpar, one of the projects they have assigned to him, and he is working on that like a young student. Sir, I welcome you on behalf of Alliance University. The research head of Kilpar, Dr. Yavai Avadayar, who is also one of my friends. We also participated in many of these things when I was a registrar in Karnataka State Law University. We have conducted these types of programs in many of the colleges. And despite his busy schedule also, he has happily agreed to participate in this function. I welcome you, sir, on behalf of Alliance University. I request Professor Shyam Kishore to hand over a bouquet to you. I welcome our beloved Dean, Dr. Kedan Gardner, for this function. I welcome Devaya and Sukanya for this function. I welcome Sham Kishore and all the faculty members, students, participants, one and all. I welcome you one and all once again. Thank you.
Thank you so much, sir. Most awaited day of this session. Like, you know what? We have been waiting for this for a long time, right? So, despite all the efforts you have taken, you all are the winners for the day, right? Give a big round of applause for the students who are presented today by breaking all their fears, coming here and just doing that. I would request Dr. Evaya Udaya sir, Research Head, Kilpa, Bengaluru, to distribute the participation certificate for our participants. Wisdom to make this country a better place, to evoke the feeling of patriotism and remind you of the nation's glory and beauty. With that being said, I request you all to stand up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Congratulations to all the winners and to all the participants as well. A big round of applause for all of them, please. I would like to extend my sincere thanks to Sri Dwarkanath Babu, Director, Kilpa, Bangalore, who supported us in conducting the event and despite his busy schedule, made time for us and graced the occasion. Thank you, sir. I extend my deepest gratitude to Dr. Evaya Udaya, the Research Head of Kilpa, for his support and presence. Thank you, sir. I would take this opportunity to thank the two incredible research people that we had today for the two of our sessions, Dr. Patil and YG Muralidharan, for their wonderful insights. Thank you so much, sir. It is with great pleasure that I thank our beloved Dr. Kiran Gardner, ma'am, for her constant support, guidance and love that she has showered on us for the help that we had for this event. I would also take this opportunity to thank our Pro-Chancellor, Abhayji Chebi, for his support and encouragement. I thank all our faculty members who are present here. A big thank you to Reddy sir and Devaya sir, who were instrumental in helping us getting the event organized and educating you all a little more apart from what you've been taught in the classrooms. So a big round of applause for all the debatees for the dais. Lastly, I would like to thank the Dean's Office executives, without whom every event that is conducted in law school is incomplete. I would also like to thank the IT department and the facilities for their support. Lastly, I would like to thank all the students who made it to today's seminar and who were kind enough to attend and sit through all the sessions and learned a little more than what they do in class. Thank you.